would like to share one information for tomorrow. Tomorrow is the International Women's Day. So to mark the occasion, the bar has organized a seminar. And the topic will be mostly confined to the women related topics. And the theme itself is invest in women. So many folks should invest more in the women. And the program will be from 1:15, but I would request all of you to be here by 1 o'clock and be a part of the program. Okay, thank you.
It is. Link to one in the From the supplementary cost list for judgment, item number 35.
For reasons mentioned in the judgment, this court is of considered opinion that the petitioner has made out a case calling for interference by this court in the impugn order. Accordingly, the impugn order dated 4th December 2014 is hereby set aside and quashed. The respondent authorities are directed to forthwith reinstate the petitioner in the service as female attendant. As regards back wages of the petitioners are concerned, the respondent authorities are directed to conduct an inquiry to find out the actual period for which the petitioner has rendered her service as female attendant and was not paid any salary. And after completion of the said inquiry, the respondent authorities shall release the salary for the said period to the petitioner. The directions issued herein above shall be given effect to by the respondent authorities within a period of 3 months from the date of this judgment. This writ petition is accordingly disposed of.
Highly obliged.
Let's your law. Software, I'd like to mention item 1.
Item 1.
This is for admission hearing. Let this matter be come up on my.
Yes, Mr. Imchen, what is your prayer? What is your prayer?
If I will be here. Actually, it is supposed to be for admission hearing. Letting suspense of it.
Item number 1. Okay. Now, what is your submission? What do you want?
I want to get it adjourned. Let come up with 2 weeks if I friend agrees.
Okay. Why are you seeking adjournment?
I have some
Personal difficulty. Heard Mr. Moin Chen Lanet, senior government advocate, who prays for an adjournment on the ground of personal difficulty. Mr. W. Marhu, Lanet, counsel for the petitioner, does not object to the said prayer, hence the prayer is allowed. Let this matter be listed after 2 weeks.
I'd like to mention item number 30 from the government. Also, we are for an appellant, but however, the within council is under medical treatment. So if this matter can be fixed listed on 26th March, Your Lordship.
You have informed the other side. Heard Miss Nuk Sung Tila, learned counsel for the appellant who prays for an adjournment on the ground that the leading conducting counsel for the appellant is not well. The Mr. B. N. Sharma, learned counsel for the respondent does not oppose to the said prayer, hence the prayer is allowed. Let this matter be listed on 26th March.
No, please, Lordship. Lordship, I beg to mention item number 21, Lordship. On behalf of the council for the applicant, Time Jubai, Lordship. Lordship, please think this most today, Lordship. So I pray that this matter may come up again on 26 this month.
Heard Mr. Vero,
Yes, Lordship.
M. Vero, learned counsel for the appellant who prays for an adjournment with consent from the learned counsel for the respondent, Mr. B. N. Sharma. The counsels for the parties prays for fixing this matter on
26.
26th of March. The prayer is allowed. List accordingly.
Applies to month.
My lord, Lordship, I beg to mention item number 22.
Yes,
Lordship, may it be listed next Tuesday, Lordship.
come
12th, Lordship.
12th. You have informed the
Yes, yes.
heard Mr. K.V. Angami, learned public prosecutor, praying for listing this matter on
12th, Lordship.
12th of March. Learned counsel for the petitioner does not opposes the prayer, hence the prayer is allowed. Let this matter be listed on 12th of March.
Right, Lord. Lordship, then item 24. May it be listed after 2 weeks.
Mr. K.V. Angami, learned public prosecutor, prays for an adjournment. Learned counsel for the petitioner does not opposes the prayer. Let this matter be listed after 2 weeks.
Lordship, I've made a mistake. May the 24, item 24 be on 12th and item 22 be after 2 weeks. Lordship.
Okay,
Right, Lord.
change according.
Right.
Yes, Your Lordship. Your Lordship, I'd like to mention item 11 on behalf of the counsel for the petitioner. Your Lordship, the notice upon respondent number 7 is still awaited. If the matter be listed after 2 weeks.
Heard Miss K. Conley Buchem,
Yes.
learned counsel for the
On behalf of the counsel for the petitioner.
submitting on behalf of the Miss V. There, learned counsel for the petitioner, and prays for fixing this matter after
2 weeks.
2 weeks on the ground that the service report on respondent numbers 7 is still awaited. The prayer is allowed. Also heard Miss, reflect her name, government council. Let this matter be listed accordingly after 2 weeks.
Much obliged. Yes, Your Lordship, I beg to mention item number 10. Lordship, regarding production this time we filed evidence.
What is your name?
Jalo,
P,
Jalo.
right hand name. Learned Government Council prays for adjournment for 2 weeks. You have informed the petition, 3 weeks. Petitioners' councils, you have informed. You have to inform. If you inform only, then your prayer would be allowed. You inform, you undertake to inform. Who is appearing for?
Keep recalling.
You don't have objection.
Yes,
Okay.
sir, the state will be filing my affidavit according to this.
Government Council prays for an adjournment for 3 weeks, which is not opposed to by learned counsel for the petitioner. Stop. Learned counsel for the petitioner has also submitted that
Yes, sir, trustee.
on respondent number,
Respondent number 4.
the notices on respondent numbers 4 has been served to Dusty Mode, and they will be filing affidavit to that effect
No.
tomorrow. The prayer is allowed. Let this matter be listed after 3 weeks.
Item number 4, similar prayer.
Item number,
4.
same order. Mr. M. Konyak, learned counsel for the petitioner, does not opposes the prayer. The prayer is allowed. Let this matter be listed after 3 weeks.
130. Similar prayer.
1-3. You have any objection? Same order, 3 weeks.
I also like to mention item number hearing item number 3. We can discuss whether after 1 week.
23.
Okay.
Any objection? Same order, 3 weeks.
Item number 8 on behalf of AIB.
1-8.
8. Can we discuss whether after 3 weeks?
Okay. You don't have any.
I also like to mention item number 14.
Okay, what is your name? You repeat your name.
Pichano.
P spelling?
Pichano.
Pichano.
Okay.
Okay.
And Roshi, item number 14. On behalf of Subhit Chandra. Roshi, can you discuss whether after 3 weeks?
Item number 8 and 14, same order. You don't have objection.
I'd like to mention item number 19. I pray that this matter may be listed on Monday. It is a consensus prayer, ma'am.
Criminal appeal.
Yes, ma'am.
Heard Mr.
And,
N. Long Kumar, learned counsel for respondent number 1 and 2.
oh, my lord, my apology, my lord, 32.
30,
Item 32.
item 32. Heard Mr. 32 is with another revision petition. You are for
I am for the respondent,
which is private?
private respondent.
Heard Mr. N. Long Kumar. Learned counsel for the private respondent who prays for fixing this matter on,
Monday,
that
Yeah.
is, date is
11th.
on 11th March. Miss Conley Buchem, learned,
On behalf of Cynthia Miyamachi.
your name is also there.
Yes, sir.
Learned counsel for the revision is, does not opposes the prayer, hence the prayer is allowed. Let this matter be listed on 11th of March.
May I please, your lordship, I beg to mention item number 25, 26 and 27. I may list this matter for 4 weeks since my senior is in this place.
Okay, what's your name? What is your name?
But at the
I'm not getting it.
my name, Berta Tep,
B.E.
BERTA.
But heard Miss Bertha
Tep.
Tep, learned counsel for the petitioner who prays for an adjournment on the ground that her senior, who is the conducting counsel in this case, is indisposed. Miss Levika, learned government counsel, does not opposes the prayer. Hence, the prayer is allowed. Let this matter be listed after 3 weeks, after 4 weeks.
I also beg to mention item number 5 on behalf of my colleague Inaholi. The Lordship, I'm informed that she is yet to receive instruction in this matter, so 3 weeks may be granted to file counter affidavit, Your Lordship.
Ms. Levika, Learned Government Council, submitting on behalf of Ms.
Nina
Nina Holle, Learned Council for the state respondent, who prays for an adjournment for 3 weeks on the ground that the council is yet to receive any instructions in this matter.
Your Lordship, a similar prayer for 7, also item 7, on behalf of Inaholi.
Prayer is allowed. Let this matter be listed accordingly. Next item,
Item 7. Same prayer on behalf of Inaholi.
same order.
Much obliged.
Mr. Lordship, I beg to mention hearing item number 43 and 34. Lordship, my seniors is in a court number 1, so if this matter come up after 2 weeks.
He is in court number 1.
Yes, if it's matter, Your Lordship.
After that matter, he can come.
This is the proper case also, Your Lordship. Already, in the similar case, the matter has been dismissed, so that actually will cover the same case.
But they are praying for adjournment for?
15 weeks, Lordship.
No, let it be called for in due course. If your senior is still on legs, we will adjourn it. Otherwise, we will take it up. Okay?
May it please Your Lordship, I'd like to mention here in item number 50. If Your Lordship may kindly may allow this matter to be passed over a day.
Item number 20.
Yes, Your Lordship, here in item number 50.
What is your name?
Giving here, I'm standing on behalf of my senior Joshua. Yeah.
Next week. Heard Mr. Kevi
On behalf of my senior Joshua.
Kure submitting on behalf of Mr. Joshua Seki, Learned Counsel for the petitioner, who prays for an adjournment. Also heard Ms. V. Chopre, Learned Additional Advocate General, who concedes to the prayer and submits that this matter may be fixed on in the next week. The prayer is allowed. Let this matter be listed accordingly.
Your Lordship, similar prayer for item number 9.
Who is for the government side? No.
No one has come till that, Your Lordship. We have issued notice to
Okay.
registrating.
Okay. Prayer for same order. Prayer for adjournment is allowed. Let this matter be listed after 2 weeks.
Resolution.
For admission, item numbers 2 and 3.
Lordship, here, the judgment passed by this court has been complied, has been placing the order. Separate that, the content may be closed.
You have anything to say?
I have already, given the, original, opinion order to, CEO.
Who was the contempt petitioner?
Item number 2 is McType form and item number 3 is A Yonju form. No, please get them back. I'll put them back.
What was the grievance? What was the order, direction?
To regularize the, petitioner.
You have anything to say? heard Miss. What is your name? Berta Tape, learned counsel for the petitioner, also heard Miss V. Sukri, learned additional AG, who submits that the order of the court against which this contempt petition was filed has already been complied with, and in support of her contention, she has produced the office order dated 21 February 2024. Stop. On perusal of the office order dated said office order, it appears that the services of the petitioner, Mr. H. Metkai, has been regularized as R. Khalasi against the post created with cabinet approval number CAB dash 1/14/2023 dated 23/1/2024. In view of compliance of the order against which this contempt petition was filed, nothing remains in this contempt petition, and therefore this contempt case is hereby closed. Similarly, in item number 3. Same order, instead of petition, change the petitioner name instead of Metkai form. Here the name would be Y Long U form, and quote the letter number from the letter here. The contempt case is accordingly closed.
For admission, item number 6.
Who is there for? None appears for the petitioner on call. Let this matter be listed after 2 weeks.
For orders, item number 12.
Service upon response before and 5 is still awaiting. However, Lordship, the notice has been taken in the month of November last year. It's overdue for almost four months. Fresh step. I may be allowed to take fresh step.
This is item number 11. 12. What's your name, Mr.? Mr. Aliba Ozukum, learned counsel for the petitioner. Heard Mr. Aliba Ozukum, learned counsel for the petitioner. On perusal of the office note dated 17/11/23, it appears that the service of notice on respondent number 4 and 5 has not yet been. No report has been received as regards the said respondents. The petitioner's counsel pray for allowing the petitioner to take fresh steps on the said respondent. The prayer is allowed. The petitioner shall take fresh steps for issuance of notice on respondent number 4 and 5 by registered post with AD within 3 days from the date of this order, returnable after 4 weeks.
Interim order may be.
The interim order shall continue till next date, list accordingly.
Orders, item numbers 15 to 17.
Well, in this case, my lord, there are basically two recoveries and two IA also.
Yes.
So on the last day of the hearing was also. It was submitted, my lord, on the instruction of the client. The charge sheet was submitted in the Nagaland PS case that is pertaining to WPC 6.
WPC 6.
6.
Okay.
So my.
Why this,
Yes,
why this IA is for?
IAs was one for the modification by the ED council and the other is for my side matter for the modification of the order that is given final effect. So now.
No, modification of which order?
My lord, in between the pending of the criminal petitions, my lord, final order was passed.
Fine.
Attaching the interim order of it.
Okay.
So for that, there was a legal issue, my lord, accordingly, because there was neither attaching order, neither the stay order was there also. So in that event, I have to find this IA. So now a new development has taken place today with the newspaper also. That he has submitted the final copy. So in between, my lord, last time WPC 6 was heard because of the fact, my lord, that this WPC 3's matter is born out from WPC 6 matter, my lord. Because without the predicted offense, there cannot be any case.
This WPC 6 relates to what matter? What is the,
WPC 6 is, I guess, question of the FIR. The FIR, it will relate to the predicate offense.
okay,
Thereafter, it goes to the, for attachment, it goes to the adjudicating authority. That 3 is with in relation to the adjudicating authority.
Absolutely. So my contention is that on the day I agree, my lord, at length to an extent, my lord, that after reading the whole contention of the FIR, my lord, there is no whisper of my name, neither any whisper of my company. So there being the position, if there is no predicate offense against me and no charge sheet is laid down, my lord, then there cannot be any attachment order under the provision of the PMLA and also of the guidance as narrated by the Honorable Supreme Court in that Mondon's case, my lord. So now I think if your lordship takes up WPC 6, my lord, on the last day, the order is that the PT order, the PT is supposed to take instruction.
no, which should we take up first? WPC 6. Where the prayer was for quashing of the FIR as relates to predicate offense. Okay.
Because our instruction was that no charges have been filed against us. But on the inquiry, we came to know subsequently, your lordship, the charge sheet is not filed. Now, for him to say, my lord, because in view of the above, the learned PP shall obtain necessary instruction and produce the scanned copy of the charge sheet submitted before the trial court of the next day.
Just let me understand. What was the order in WPC 6?
My lord, if the 6th, the order goes like this, shall I read it?
Last order is on 2nd of February.
No, my lord, it will be on 15th February.
Just a minute. February order is not there. Albert. Where is 15 February? Also. Maybe in WPC number 3.
It may be tagged in WPC three, it may be, because we have downloaded the order. Because common order is being on the. Maybe also in IA. In IA one, we will have to check it.
I number?
IA one of 24 years.
It was passed in I. Okay, the PP was directed to submit the charge sheet, scan copy of the charge sheet. Now, what is the status?
Lordship has submitted the letters. It is not yet submitted. The justice is not yet submitted.
Not yet
Not
submitted.
yet.
So who made the submissions that?
Yes, my lord, we had the instruction, my lord, because we checked it out from demarcated board as well as Kohima board at that time. The local council somehow submitted, my lord, and on my instruction council submission, I have made this.
Okay, so the status is that charge sheet has not been
Not been
submitted.
So that is one aspect, but if your lordship would also kindly turn to the order dated 18/8/2023 in WPC 6 madam. 18/8.
This order ought to have been passed in
Yes.
WBC 6.
Basically, that order should have been there, madam, since board.
Albert. Yeah, here
In
everything
WPC
is, everything
6
is
order
mixed up.
dated
Now, this is
18/8/2023.
WPC criminal 3 order sheet. It is in WPC 6. So it has to be properly maintained. Yes, which order?
Madam, 18/8/23, madam.
In WPC
WPC 6, madam.
6. Actually, orders are not, yes,
Madam, we have taken the order sheet of 18/8/23 on the last para, madam, on the next date fix. Shall I read, madam?
yes.
Last para, on the next date fix, the learned.
No, this is not the order which I am.
It may be in 3 also, madam.
18/8/2023 passed in WPC. 6. Yes, 18/8/2023.
Yes, yes.
I got it.
Yeah.
Yes.
So I'd like to take your lordship to the last paragraph of the order. On the next day, fix the learned public prosecutor shall produce the scanned copy of the FIR in Kohima cyber crime case number 3 of 21 and the scanned copy of the case diary in the same case. So what right now I'd like to submit my lord. Now I'm heavily banking on WPC 6 because if I can overcome the bar, my lord, that there is no predicted offense against me because that case relates to some HP in total, which I am no way connected with.
Okay.
So that's why this hearing has.
What is your relief which you are seeking in WPC three?
WPC three was originally filed for the provisional attachment
Of the
of the attachment order passed by the ED authority.
attachment of properties of
Yes,
the,
property, movable, immovable.
of the petitioner?
Yes.
Okay.
So on the basis when we filed the quashing petition, my lord, we came to know that this case has been filed on the basis of the HPG token case, which is Kohima cyber PS case number 3 of 21.
Which you are praying for quashing?
Yes, my.
Okay.
Then subsequently I filed, that's why it is 6, my. Earlier we filed for the attachment, provisional attachment order. Your lordship has also dealt with at the very inception, madam. Then subsequently, as the case progressed, we came to know that this WPC 3 is related to the cyber PS case number 3 of 21. Then we immediately swung into action and filed the WPC 6.
Okay.
So now that's why, my lord, I am heavily banking on one contention, my lord. That is, there is no allegation against me in the FIR of cyber PS case number 3 of 21 relating to WPC 6. That's why I have came up for quashing of the FIR.
No.
If the predicted offense goes, my lord, your lordship is aware, as per that Mondal's case dealt with by the Honorable Supreme Court in 2022, my lord, it is clearly stated that in order to have a PMLA case, there must exist a predicted offense, scheduled offense. So since I am no way connected and neither anything has been found for me, neither anything has been seized from me, my lord. So in that event, my lord, for the crime, my lord, or in that event, my lord, the whole case of ED will fall flat, my lord.
Okay, you were referring to the order dated 8/8/23, 18/8/23.
Yes, my lord. So if the diary and all these are produced before your lordship, my lord, we will do the final hearing, my lord. So that it can
Now,
come
whether
to
it is
logical
before-
conclusion.
There is there and scan copy of
We are
FIR.
ready also to do this.
So
And so for the other case, my lord, WPC 3, this I'm giving the backdrop, my lord. Today morning newspaper, we came across, my lord, that ED has filed the final complaint, my lord. So we'll have to take instruction, my lord, from the client as to the fate of this matter.
both the cases are connected cases.
Serious. Should I just?
Please.
As it is, there. Yes, how that But so far as PMLA is concerned, he need not be named in the FIR because the money rolls. And that is what has been held in the case of Madan Lal Chaudhary. You need not be named in the FIR. It starts from there. But it goes in other circles. The money rotates, it goes to various circles, various pockets. So he need not be named in the FIR. Supreme Court has said that. Secondly, once the proceeding has been taken up by the EB, provisional attachment was made. After the provisional attachment, it goes to the adjudicating authority under Section 8. The adjudicating authority has confirmed the attachment. After confirmation of the attachment, he has been made an accused. A complaint is filed before the special judge. Now, whether your lordship will delve into those matters. Because rightly, wrongly,
No, in section, in WBC 3,
3 is,
what relief is seeking?
he is against the summons issued to him by the adjudicating authority, so far as the proceeding for confirmation under section 8 is concerned. Now that section 8 proceeding has been confirmed, attachment has been confirmed. Once the attachment has been confirmed, now a complaint in which he is also an accused has been filed before the special court day before yesterday. So when that proceeding is there before the learned special court, whether your lordship will look into this, because so far as my understanding goes, WP Criminal 3 of 23 has more or less become infructuous,
Okay.
because it was only for the purpose of attachment and confirmation. Confirmation has been done. So far as the challenge to the FIR is concerned, subject to what my senior says, the Supreme Court says that the person need not be named in the FIR. The decision which is holding forth right now, Vijay Madanlal Chaudhary, it says he need not be named. He is not named, but the authorities have found something against him. And he has been made an accused in the complaint case. The complaint is filed. So that is the status as on date. Under those circumstances, whether your lordship will now go to the question, or my friend will challenge the proceedings before the special court.
As regards
The complaint
WPC 3,
6.
not the,
3 is attachment. Attachment.
no, attachment, whether they will, he's raising 2 points.
Yeah, madam, right now, without instruction, it will not be feasible.
As regards WPC number 3,
3,
okay.
but 6 will continue definitely, but 3 we have to seek instruction from the client's mind. For withdrawal, as your lordship is aware of, it's a client's concern. We'll have to,
That also they have got a remedy for appeal.
all remedies are there now, whether the client is being informed.
No,
so that-
today we may proceed with hearing of WPC 6.
If your lordship wishes.
No, what other option is available?
Because so far as him being an accused, lordship, I would.
No, whether his plea, your plea is the only plea is that your name is not in FIR.
No, not only.
There are other grounds also.
There are, but first, my lord, for quashing of an FIR as your lordship knows, my lord, that there must be certain circumstances to show that I am involved in that case. On the plain reading of the FIR, it is not coming. Now during investigation, I don't know what is coming against me, because neither this accused petitioner who has come, Upesh Arora, my lord, he is not an accused named in the FIR. Neither his company, there are these having 2 companies.
No, if you are not named in the FIR, what
Yes.
is your grievance against the FIR?
They
During
have-
investigation,
That is the
some
grievance.
matter,
Absolutely, my lord. That is the whole grievance, my lord. That without I being having any criminal cases, how can I be taken into the ambit of the PMLA Act?
That is what is permitted by the PMLA.
No, that's what I say. Some substance should come out. No? Out of blue, he cannot, in a stray case involved.
no, I am trying to
Yeah,
understand.
He also.
Your name may not be there in the FIR, but during investigation, if some matters,
Yes, that is what I'm trying to. That something should come out. I don't know now what is something in the case diary, because I don't have access to the case diary. I have only access to the public document, that is the FIR. From the FIR, it transpires that one HP with token is involved and 2 other firms where the money went. That is Lillian and the other one is Sharp. So these 2, which I am nowhere related, they have just dragged me as a dragnet and made me a party to that proceeding, which is not permissible under the law as part of Vijay Manduk's case, your lordship. So for that, there must be a predicted offense wherein the schedule of offense is not good. So if there is no whisper in the FIR, my lord, in the case, my lord, I leave the FIR, my lord. He is rightly submitted, my lord. That's true. As your lordship knows also,
in an FIR, a person may not be named, but subsequently during investigation, the accused may be identified, accused may be prosecuted. For that, it's not that always it should be named. Only when it is named, my lord, then the.
Okay, today this is listed in orders column.
I will also have to take instruction for WPC 3, my lord.
So we'll fix it for hearing.
My lord,
Let him take
let us fix a date for 2 occasions, my lord. I'll take.
let him
instruction.
take instructions in WPC 3 in view of the development which. And in 6, the matter is ready for hearing.
Yes, yes. It may be fixed in the hearing column, my lord.
Okay. In WPC number 6. Heard Mr. Where is it? WPC 6 heard Mr. Z. Kamar Leonard, Senior Counsel, assisted by Mr. Z. Khalid. Also heard Mr. R.K.D. Chaudhary, Leonard.
In WPC
6,
6, I am for 2 and 3.
Leonard, Deputy SGI,
Yes, sir.
appearing for respondent number
2 and 3.
2 and 3.
One is not.
Also heard Mr. K.V. Angami, Leonard, Public Prosecutor for the state of Nagaland. In pursuant to the order dated 18/8/2023, the learned public prosecutor has produced the scanned copy of the case diary of Cyber PS case number 3/21, as well as the FIR of the said case. It is submitted at bar that the case is ready for hearing and it may be fixed for hearing on.
On my lord, let me, my lord, we are suggesting this, my lord, saying on 21, 22, 21, 22, my lord. 22, my lord.
22.
April. 22.
Monday.
On 22 April 2023-24.
In the meantime, we will also go through the charges of allegation at the level so that I can combine it and some.
In WPC number 3/2023, heard counsel for the both sides. It is submitted by learned senior counsel for the petitioner that they have come to, it has come to notice of the learned counsel for the petitioner through newspaper that charge sheet has been laid. Final complaint has been.
And he has also submitted.
Final complaint has been submitted by the adjudicatory.
No, by the enforcement.
By the enforcement director, enforcement directorate. Stop. In view of the submissions, in view of the said facts, learned senior counsel for the petitioner seeks some time for taking necessary instructions from the petitioner in this regard. The prayer is Dusty mode was allowed.
Yes, sir.
What was the order which was passed? Because 2017 is,
Worship, after the publication, this honorable court has proceeded ex parte with Lordship. But
okay,
however, during the process of hearing, it was understood that that dusty service was important. So likewise, we have.
by which order the Dusty service was first directed?
Lordship. 30/10/2023, Lordship,
30/10,
30/10/2023.
2023.
Here, as per, even, on 12/19/23. On 12/19/23. As per the order. 12/19/23. It says, after hearing the matter for some time, this court is of the view that respondent number one remains absent despite the publication of subsidiary notice. And as per this court's order dated 4/8/2022, it shows that service upon respondent number one is deemed to have been served. Since the matter relates to money degree in respect of respondent number one, the learned counsel for the appellant is directed to obtain instruction as regard the status of the plaintiff of which she is granted bond type. So likewise, Lordship, we have, we tried our best to trace the respondent number one. And then the next order was to proceed for custody service. Likewise, we have initiated.
No, but once the notices were deemed to be served, why this court felt that again notices be? Now what is to be done? Because once the notices were deemed to be served through substituted services, that through newspaper publication, then it proceeded for hearing. During the course of the hearing, it was felt that
That was the opinion of this honorable court. So you have complied.
now what? Now even through trying to serve the notice through Dusty mode, you could not find the whereabouts of
Yes, sir.
the respondent number one.
As per the report, it says, even the witnesses, they saw in a marriage party 2 years back at Rajasthan, Lordship.
Then we may proceed with the hearing.
Lordship.
We will fix, next week we will hear it.
Yes, Lordship.
Heard Miss Noksum Tila, learned counsel for the appellant. Who is appearing for the other respondents? State respondent.
State respondent, Miss Violet. Additional application.
None appears for the state respondents. Learned counsel for the petitioner, learned counsel for the appellant has submitted that in pursuant to the directions of this court, no, it is treated to be complete. The service is deemed to be complete. Then we may go ahead with hearing. Because on last date, 15/2/2024, there is an observation that notice upon respondent number 1 is treated to be complete.
Yes, Your Lordship, that was the order. But however, the court was of the opinion that to get further information of respondent number 1, since it relates to the money matter.
No, that was the order on 15. That since it relates to money, that was order passed on 12/9. 12/9. You read the last order. Last order dated 15/2/2024. Last order, where there is an observation that notice upon respondent number 1 is treated to have to be complete. So this is ready for hearing.
Yes, Your Lordship, then this matter can be taken up next week.
Heard again. Heard Miss Noksuntila, London Counsel for the appellant. None appears for the respondent number 2 to 4. On perusal of the orders dated 15/2/2024, it appears that notice on respondent number 1 is deemed to be complete. Stop. And this case is ready for hearing. On request of learned counsel for the appellant, let this matter be listed for hearing. When? After a week. I'm not giving a fixed date.
Yes, Your Lordship. Much obliged.
For hearing item number 19.
House list, yeah, not there. Somewhere there. Yes,
Please, my lord.
you are ready, ready? Ready for hearing,
Yes,
both sides.
yes, Lord. Lordship,
Yes.
this kind of cases, I don't know whether the happen only in my state or. But Lordship, the text in exist is that the respondent number 1. He took money from the appellants amounting to 79 lakhs and 16,000. Lordship.
79 lakhs.
Yes, 79 lakhs and 16,000. On the promise that he will provide government job to them as well as to their family members. And later on, Lordship, appointment order was handed over to them.
Appointment order was also given.
Yes, yes, but it was later discovered that all the appointment orders were fake, that he had manufactured himself. So FIR was filed. Case was taken up before the magistrate's court at Mohsuk district. Charge was also filed, and the respondent number one was charged with under 3 sections, Lordship. 420 in that penal code, 468
And
and 471. That is forgery, cheating, and dishonesty. Now, all these are magistrate trial cases as per the schedule provided under the criminal procedure code.
okay.
Now, accordingly, when the matter was pending before the magistrate's court, and even today, Lordship, this is quite normal in Nagaland. A single magistrate or a single sessions judge looks after different districts. So the magistrate Moka was additionally looking after Mohsuk district at that relevant point of time. It was not the case that there was no regular magistrate. Now, when the matter was pending before the magistrate's court, and when she
Where?
At
Mokokchung,
Mohsuk. Yes. And when she was sitting at Oka, because the Oka magistrate was also looking after the Mohsuk district.
Hmm.
The relevant notification is at page 69. Lordship. In order to satisfy this honorable court, page 69, the relevant portion is at page 70. The last line, Lordship, page 70, last line.
Yes.
The Honorable High Court further recommends that Srimati so-and-so, Civil Judge Junior Division, CAM JLFC, Moka will look after the works of Chief Judicial Magistrate Mohsuk as in charge in addition to her own duties. So, this order is dated, the notification is dated 20th February 2018, Lordship, passed by this honorable court. So now, when the matter was pending before the magistrate's court at Mohsuk, without any committal order, Lordship, because if the magistrate comes to an opinion that the case is triable by the sessions judge, then a committal order has to be passed under 323 CRPC.
Yes.
Now, without anything, Lordship, the sessions judge, he took up the matter on his own.
Session Judge Mokokchung.
Yes, Lordship. And then the respondent number one pleaded guilty. And a fine of rupees 1,000 was imposed.
Okay.
To both I may be allowed to take my lordship to page 82. I have enclosed the impugned order.
No, the story, complete the story.
Yes, yes. Now, lordship, that is the entire story, lordship.
Respondent number one pleaded guilty and
Yes.
1,005.
Yes,
Fine.
respondent number 1 and 2, both pleaded guilty. There
And
were 2 accused.
you are the first informant.
Yes, lordship.
You are the person who lost the FIR. Appellant
Yes,
here,
lordship.
so you are aggrieved because of lesser punishment.
Yes, lordship.
Okay.
Not only that, lordship. Not only that, lordship. My contention, lordship. One is the lesser punishment, lordship. Now, secondly, lordship, the sessions judge could not have.
This appeal is under what provision? 3. 374
374.
and 372 also.
Yes, Lordship.
You were the victim.
Yes, Lordship. 5 of us filed the FIR, Lordship, before the police station 2 also.
Okay.
Now, investigation was conducted, Lordship. And charge sheet was accordingly filed. On the 18th of May 2017.
No, you are against the, what is your grievance against the order of conviction because he pleaded guilty.
Yes, Lordship. And Lordship, that since the Sessions Court has taken up the matter without any committal order
Committed.
passed by the magistrate.
Okay. Procedural irregularities.
Yes, Lordship.
But do you have any grievance against the order of conviction?
The case should be sent back to the magistrate's court, Lordship. Because
These are triable by the magistrate
yes,
tribal case.
exclusively, Lordship.
It is not session tribal case.
No.
Okay.
The Schedule 1 under the Criminal Procedure Code is very clear, Lordship. If I may take my long.
Okay. 420, 468
68,
and 471, all are magistrate tribal case.
Yes. Now, without a committal order, the Sessions Court cannot take up a matter. If there is a committal order, then I have no issue, Lordship.
Okay, now begin.
So, if I may take my lord to the schedule of the Criminal Procedure Code,
Yes.
the classification of offences. I'll be making only a very brief submission and the one decided case up and then I'll wind up my submission. The first schedule, classification of offences. Under it, Lordship. 420. IPC, imprisonment for 7 years, cognizable, not bailable, triable by magistrate of the first class. And 468, forgery for the purpose of cheating, imprisonment for 7 years, cognizable, non bailable, magistrate of the first class. 471, using as genuine a forged document which is known to be forged. When the forged document is a promissory note of the central government. Punishment for forgery of such document, cognizable, bailable, magistrate of the first class.
The allegation was that he took 79 lakhs.
Yes, 79 lakhs and 16,000 dollars.
And the punishment was 1,000 only.
Yes.
Okay.
That's a very sizable amount, Lordship.
Okay, proceed.
Now, this is order to satisfy my lord that without the committal order, the sessions judge could not have taken up the case, which is exclusively triable by the magistrate's court, Lordship. I may be allowed to read from paragraph 10. Here they have referred to some other Supreme Court judgments and some other judgments filed by the Honorable High Court across the country. So I believe this citation itself will suffice. So from paragraph 10, Lordship, if I may read. At the outset, reference may be made to the provisions of sections 323 and 326 of the Criminal Procedure Code, which are set out below. 323. Procedure when after commencement of inquiry or trial, magistrate finds case should be committed. If in any inquiry into an offence or a trial before a magistrate, it appears to him at any stage of the proceedings before signing the judgment that the case is one which ought to be tried by the court of session, he shall commit it to that court under the provisions herein before contempt, and thereupon the provisions of chapter 18 shall apply to the commitment so that. Chapter 18, as my lord is aware, deals with sections tribal cases. The next, if I may read the next paragraph, Lord. In Superior, this is reported in 2001 to SCC 688. The Supreme Court observes that once a matter has been committed by a magistrate to the Court of Session under Section 323 of the CRPC, the provisions of Chapter 18 of the Criminal Procedure Code would be applicable. 12. In Dr. G. Ilangowan, the Madras High Court considered the scope of sections 323 and 326 of the Criminal Procedure Code in a situation where 13 witnesses had been already examined before the magistrate committed the trial to the Sessions Court. The Madras High Court held that once the case has been committed to the Sessions Court would have to proceed as per the provisions of Chapter 18 of the CRPC, and in such a case, provisions of Section 326 of the CRPC would not apply. The relevant observations are set out below. A reading of Section 323 of CRPC clearly shows that if any inquiry into an offense or a trial before the learned magistrate, it appears to him at any stage of the proceedings before signing judgment that the case is one which ought to be tried by the Court of Session, he shall commit it to that court under the provisions therein. Lordship, the word used is shall, Lordship, even under the Criminal Procedure Code. That means without the committal order, Sessions judge cannot take up the case. Thereupon, provisions of Chapter 18 of CRPC shall apply to the committal so made. Chapter 18 of CRPC starts from Section 225 CRPC to 237 CRPC. Therefore, any magistrate or metropolitan magistrate cannot be acquainted with the Sessions judge and language employed is committal. Though the aforesaid provisions say that if the case is triable by the Sessions judge, the case has to be committed by the magistrate. The magistrate includes Chief Metropolitan Magistrate and Chief Judicial Magistrate. Once the case is committed, the committal court, Sessions Court, follows the procedure as contemplated under Sections 225 to 237 CRPC. 18. The language employed in both Sections 323 and 326 CRPC is very clear. In this case, since Chief Metropolitan Magistrate has no jurisdiction to try, as he has got power only to pass sentence for a term up to 7 years, he has committed the case to Court of Session. Therefore, once the case is committed to Sessions Court as per Section 323 CRPC, provisions of Chapter 18 has to be followed. In such view of the matter, the Chief Metropolitan Magistrate cannot be treated as predecessor of the Sessions Court, and the Sessions Court cannot be stated as successor of Chief Metropolitan Magistrate. As per Section 323 CRPC, the procedure when, after commencement of inquiry or trial, if the magistrate finds case should be committed, if any inquiry into an offense or a trial before a magistrate, it appears to him at any stage of the proceedings before signing judgment that a case is one which ought to be tried by the Court of Session, he shall commit it to that court, and thereupon provisions of Chapter 18 shall apply. Therefore, Section 326 CRPC regarding evidence, partly recorded by one judge or magistrate and partly by another, cannot be applied herein. The SLB against the aforesaid judgment was dismissed by the Supreme Court, while overdated 18 April 2022. Similar sentences, Lordship, and cases have been narrated from paragraph 14 to paragraph 16, Lordship. If I may continue from paragraph 17.
Yes.
I am in respectful agreement with the aforesaid views taken by the High Court of Madras, Punjab and Haryana and Madhya Pradesh. The mandate of Section 323 of the CRPC is clear. When a case is committed by a magistrate to the Court of Session, the trial would have to begin de novo. The Court of Session would first frame charges and then proceed with the examination of the witnesses. When a case is committed by the Court of Session to Court of Magistrate to the Court of Session, the magistrate becomes factus officio, and any evidence recorded therein cannot be held to be admissible for the purpose of a de novo trial before the committal court. Therefore, the evidence would also have to be recorded de novo. 19. Section 326 of the CRPC covers cases wherein a magistrate judge has been succeeded by another magistrate judge, and such successor can act on the evidence recorded by his predecessor. However, as correctly observed by the Madras High Court in Dr. G. Ilangovan, the Sessions Court cannot be treated as a successor of the magistrate. Therefore, Section 326 of the CRPC would not be applicable to the present case. 20. With regard to the submission on behalf of the complainant that a de novo trial would cause prejudice to the complainant on account of delay, it is pertinent to note that it was the complainant who moved the application for committal before the learned MM, which was rejected by order dated 4th July 2014. Thereafter, the complainant preferred a revision against the aforesaid order, which was allowed, and consequent to the learned MM committed the case to the Sessions Court. In view thereof, the aforesaid submission cannot be accepted. In view of the above, the present petition is allowed, and the impugned order dated so and so passed by the learned ASJ is set aside, and it is directed that the trial shall proceed before the Court of Session from the stage it was before the impugned order was passed. Counsel 22. Counsel for the complainant submits that since one of the witnesses, PW1 so and so, has since expired, therefore his evidence cannot be recorded de novo. In terms of Section 33 of the Indian Evidence Act 1972, evidence given by a witness in a judicial proceeding can be considered relevant in a subsequent judicial proceeding in case the witness has since expired. In view thereof, it is directed that the evidence of PW1 recorded before the Court of Magistrate shall be read in evidence before the Sessions Court. 23. However, taking note of the fact that the present FIR was registered in the year 2003, the learned ASJ is requested to expeditiously complete the trial in the present case, preferably within a period of 6 months from the date fixed. So, Lordship, in short, in at least without the committal order, the Sessions Court cannot take up cases exclusively triable by the Magistrate Court. There is a rule of law, Lordship. And if courts does not respect each other's jurisdiction, it will create chaos in the society as well as in the administration of the judiciary.
Whether any Sessions case was registered, the plea of guilt was
Yes.
passed in which case?
Before the Sessions Court.
In which case number?
GR 03 of 2016. It relates to the same case in connection with PS2 Mokchong case number 2/16.
How the records of GR 03 2016 went to Sessions Court? How the case record went there?
Lordship, that is why it is surprising, Lordship. How
Because it was pending before the Court of Chief Judicial Magistrate Mokokchung.
Yes, sir.
And the session judge was not in charge of Chief CJ Mokokchung.
Okay.
The civil judge Wokha was in charge of CJ Mokokchung.
Yes.
Then from the Court of CJ Mokokchung, how this record went to the Court of Session? No, what record says?
Nothing, Lordship.
We have
So far
the
as
original
I'm
record. The trial court records are there, no?
The then principal district and session judge also has retired, Lordship. He retired shortly afterwards.
Okay. Order dated 25/9/2018.
Yes, sir.
As there is no regular judicial magistrate posted at Mokokchung, I am inclined to take up the case for he himself took up.
Yes, Lordship.
for speedy trial.
Yes.
This cannot be done. Okay.
So my prayer before this honorable court is that Lordship, let the case be continued, Lordship, before the magistrate's court in the interest of justice. Whether the accused is acquitted or convicted, Lordship, that is a different matter, Lordship. But so, in order not to erode the confidence of the public, Lordship, in the judiciary, the trial may continue till its logical conclusion. Because investigation has already.
No,
been
this
completed
appeal is by whom?
by the FIR complainants, Lordship.
Under 372 only.
Yes, Lordship. Please,
Under which provision you are preferring this appeal? 374 or 2?
374.
Because you have mentioned both 374,
Yes,
372, 401, 397, you have left nothing. You have made a mixture of appeal and revision.
Yes, Lordship. I have quoted the paragraph 8, section 372, Lordship.
372,
Yes. 372, Lordship. I have quoted the paragraph 8 of my.
okay. Though in the cause title you have mentioned everything, but in para 8 you have stated that this is an appeal under section 372.
Yes, the relevant portion, if I may read, Lordship, which I have reproduced. 372, a paragraph that states that, provided that the victim shall have the right to appeal against any order passed by the court acquitting the accused of convicted for a lesser offense or imposing inadequate compensation.
No, there is a wrong statement. You have preferred this appeal under section 374, read with 372,
Yes, Lordship.
397, 3401. Everything cannot be mixed up together.
Yes, Lordship.
Because different provisions are
Yes,
there for.
yes, Lordship. I
So-
completely agree with that.
So then, under what provision should we treat your appeal to be?
374, read with 372, Lordship.
For 372, you have to fall in category of victim. And
Even the facts and circumstances of the case, Lordship, I am a victim, Lordship.
And 374 is available to only convicted person, not to you. We'll hear you, but let him make clear. Because you are on provisions. The session judge without committal
Even the Lordship,
took up the trial.
yes, even the Lordship, I believe I have the liberty, Lordship, to approach this honorable court under section 401, Lordship, under the revisionary jurisdiction of the Lordship. Because High Court's power of revision, Lordship.
No, High Court's power is there. If it is there, even if not in anything else, under 227 power is there.
Yes.
Powers of superintendence is also there.
Yes,
If something grossly wrong is going on,
yes,
High
Lordship.
Court can take
Yes.
cognizance.
Yes.
But
And
my
I-
query to you is, under what provision your appeal should be treated? It cannot be under 374.
If it cannot be under 374, the Lordship, it has to be under 401.
Then it will not be an appeal,
Yes.
then it will be treated as a revision.
Yes, Lordship.
Now, whether that order is revisable order, those questions will arise. The order of conviction on plea of guilt.
If it can be taken up with 2, Lordship, then I.
Yes,
perhaps I
you-
can,
you-
quick citations, Lordship.
You,
In order to.
no, we'll continue. Mr. Long, we'll hear him and you answer these queries at 2. That under which provision this appeal should be treated to be. You have quoted many provisions.
Yes.
You have to satisfy that under 374, it can be taken up, or under 372, it can be taken up,
Or under 401.
or under 401, though you have filed it as an appeal, it may be taken up as a revision under 401. Or whether High Court on its own, after coming to know about the state of affairs, take it up as a case under 227 of the Constitution of India. Where is the power that you have to show at 2? Yes, Mr. Long comment.
Yes, my lord. As your lordship has rightly pointed out, this is a criminal appeal. The cause title itself is a criminal appeal, my lord. So it has to be read under section 374 of the CRPC. And then section 374 of the CRPC, it has to be by the convicted persons. Here, the appellants are not the convicts, nor they are the victims, my lord. The victims are those against whom the appointment order was, a fake appointment order was issued. They are only the complainants. They are the persons who have handed over the money to the respondent for paying to the respondents for availing government job. They are not the victims. The
They
victims,
did not pay money. Money was paid by somebody else.
yes, rather
In
they are
lieu
also
of-
involved
Okay.
because the respondents have asked the appellants here that whether there's any candidates who wants to get employment in government service in the police department. And then it is the appellants here who have engaged the clients, and then to them, through the initiative, I should say, they have managed to get some clients for availing the appointment. So they are not the victims. They are also parallelly responsible. So as for section 374, it should be has to be by the victims or the convicts.
Oh.
And my lord, let me take you to the prayer of the appellant, my lord. Page 11. Page 11 of the appeal memo.
Yes.
Here, the prayer, I may be allowed to read, my lord, page 11, prayer. In the premises of proceed, it is most respectfully prayed that your lordship may be pleased to admit this appeal, call for a recourse, issue a rule calling upon the respondents to show cause as to why sentence awarded by impugned order dated 25/9/2018 passed by the learned district principal district and session judge Mokjun Nagaland in GR number 3 of 2006 in connection with PS2 Mokjun Nagaland case number so and so should not be enhanced. That is their only prayer. There's nothing about reverting the matter to the CGM score.
Okay.
So the appeal cannot go beyond the prayer. So the only issue now is regarding the award of the punishment.
Quantum of punishment.
Quantum of punishment. And then firstly, whether the appellants have the right to file this criminal appeal under 374.
No, but suppose something has come to the notice of this court
Yes.
that there was gross illegality in the procedure adopted by the session judge. Whether this court will remain silent.
No, my lord. But if, yes, this honorable court has got ample power to do that also. But here, the appeal is mixed up with 374 is the appellate jurisdiction, and section 372, 397, and 401 is regarding revisional jurisdiction.
Yes.
So this is an appeal, not a revision. So the first thing to be taken into consideration is 374, section 374, where it says it has to be by the convicts. And the respondents herein are the convicts. So this appeal is not maintainable under 374.
Okay.
And secondly, it is a void contract for the respondents have approached the appellants here to find persons who wants to get employment in Nagaland Police Department. Now, Maro, there was an agreement between the appellants and the respondents herein, which is a void contract. Knowing that buying of government's job is illegal, they have committed that, which amounts to bribery and my lord, which amounts to bribery and corruption also. So they are also involved in the corruption. That's why the learned trial court has said that they are also equally responsible. So they have come to this conclusion.
Now let us go to the order of the trial court, which is.
Yes, my lord, I'll take you to the lordship. First to the here, my lord, at page number 60.
Page.
Page number 74.
Impugn order.
This is not the impugn order, but this is an order passed in civil origins by the civil district session judge in civil suit number 1, 2, 3, 4, and 5 of 2016.
No, let us not go there. This is, what is this? 6.
This is a civil suit. There was two litigations. One was civil suit and one was criminal proceeding.
No, but we are not concerned about civil.
Yes, my lord. And the impugn order is at page number 82. Annexure 1. Annexure. Yes, annexure. I. Where is my lord?
Yes.
In the court of the principal district assistant judge, Mokcho, Nagaland, GR number 3 of 2016, PS2, Mokcho, case number 2 of 16. Dated 25/9/2018 order. Learned CGM court by its order dated 15/7/17 have taken cognizance against the accused person. As there is no regular judicial magistrate posted in Mokcho at present, as such, I am inclined to take up the case for speedy trial. The brief fact of the case is that a complaint was received on 11/1/2016 that the accused Mr. Motushi and Mr. Ram Kumar Gautam has cheated the complainants on the pretext of giving employment to the complainants at police department. The accused persons are alleged to have cheated the complainants with a huge tune of rupees 79,60,000. As such, a case was registered at Mokcho PS2 under section 420-34 IPC. After completion of investigation, charge sheet was filed against the accused Motushi under section 420, 468, 471 IPC and against Ram Kumar Odam under section 202 IPC. Charge framed against Motushi under section 420, 468, 471 IPC and charge framed under 202 IPC against the accused Ram Kumar Odam. The charge was read over and explained to the accused Motushi in Nagamis, to which he pleaded guilty and prayed for leniency, and that the accused have admitted that the appointment to be secured by them is illegal and they have paid the money for illegal appointment, and that he has committed the offense as he had lots of debts which he has incurred for the medical expenses of his wife. The judge was read over and explained to the accused Ram Kumar Gautam in Nagamis, to which he pleaded guilty and prayed for leniency and stated that he has in good faith paid the consideration to Motushi to secure job for his relatives.
Who is
On the-
Moatoshi?
Motushi is the respondent, accused person,
Okay.
respondent number one. On plea of guilty by the accused persons, I am inclined to convict accused Ram Kumar Gautam with a fine of ₹200 and in default simple imprisonment of 15 days. Accused Motoshi is convicted with a fine of ₹1,000 of offense under 468 IPC and in default simple imprisonment of 2 months and a fine of ₹1,000 for offense under section 471 and in default simple imprisonment of 2 months and fine of ₹1,000 for offense under section 420 and in default simple imprisonment of 2 months. Leniency is shown considering the fact that on perusal of the reports reveals that even if the allegations are correct, the parties were pari delicto here, very delicto, because to commit an offense, employment in the government is available on advertisement and selection and not purchased by money. In the present case, the complainants voluntarily parted with money for illegal purpose of securing appointment in police department for money considering which itself was an offense. In the present case, both the parties agreed to commit an act which is an offense under the Indian Penal Code and that both had agreed to do something which is prohibited by law and that the complainant are also a parties extended to exploit the law for an illegal purpose and that the agreement itself was to commit an offense and that the investigation agency had failed no charge nor taken any action against the complainant for paying illegal gratification for securing a job of police department.
Okay.
So they are also equally responsible. And as per section 420 of IPC, the contempt of punishment is, it may be extended up to 7 years, may be extended on. It can be 1 year, 2 years, 4 years, 5 years. Even for section 468 also, for 40 also, it may be extended up to a punishment for imprisonment of which may extend up to 7 years. It says which may extend. So it may be 1 month, 6 months, 1 year, 2 years, 3 years, 5 years, 6 years, or 7 years. So there's no wrong in the finding of the learned trial court below.
Okay. Anything else?
Yes, we have also. AIR 1974, 1892, para 6, 12, and 13.
Yeah, 1974 Supreme Court.
Yes, Supreme Court, 1892, 1892, paragraph 6, 12, and 13. That's your lordship, sir.
Yes.
I need para 6.
Mr. Longkumar, I'll take a short break.
Oh, no.
Of 2 minutes. Yes.
So, my local was referring to the area of the 1892. Logical.
Yes.
Para 6. Miracle.
Yes.
We are of the view that section 65 of the Contract Act cannot help the plaintiff on the fact and circumstances of this case. Section 65 read as follows. When an agreement is discovered to be void and when a contract becomes void, any person who has received any advantage under such agreement or contract is bound to restore it or to make compensation to it to the person from whom he received it. The section makes a distinction between an agreement and a contract. According to Section 2 of the Contract Act, an agreement which is enforceable by law is a contract, and an agreement which is not enforceable by law is made to be void. Therefore, when the earlier part of the section speaks of an agreement being discovered to be void, it means that the agreement is not.
How many complainants were there in the affair? How many have lost the affair?
6.
And how many appellants are there?
5.
Yes. Read.
Yes. This, it means that it was void. It may be that the parties or one of the parties to the agreement may not have, when they entered into the agreement, known that the agreement was in law not enforceable. They might have come to know later that the agreement was not enforceable. The second part of the section refers to the contract being void. That refers to a case where an agreement which was originally enforceable and was therefore a contract becomes void due to subsequent openings. In both these cases, any person who has received any advantage under such agreement or contract is bound to restore such advantage or to make compensation for it to the person from whom he received it. But where even at the time when agreement is entered into, both parties knew that it was not lawfully and therefore void, there was no contract, but where it was discovered to be void subsequently. Nor is it a case of the contract between void due to subsequent happening. Therefore, Section 65 of the Contract Act not apply. And para 12 and 13. Para 12. The further question is whether it could be said that this contract was either discovered to be void or became void. The fact enumerated above would show that the contract was void at its inception, and this is not a case where it became void subsequently. Nor would it be said that the agreement was discovered to be void after it was entered into. As pointed out by the trial court, the plaintiff was already in the business of mining and he had the advantage of consulting its lawyers and solicitors, so there were no occasion for the plaintiff to have been under any kind of ignorance of law under the act and the rules. Clearly, therefore, this is not a case of which section 65 of the contract applies, nor it is a case of which section 70 or section 64 of contract applies. The payment of the money was not made lawfully, nor was it done under a mistake or under caution.
No, but why have you referred to this?
So I'm afraid that this seems to engage clients for the job.
No, but here we are dealing with a criminal case
Yes,
where
because
he is
I'm
not
saying-
here seeking compensation under section 65 of the Contract
Yes,
Act.
my lord. Yes.
That is
but-
not the relief which the appellant is seeking.
Yes, yes. Why I'm referring this is because the appellants, they are also at par with the respondents. So when they are equally responsible, they are also liable to be punished. They have no right to file the appeal because there was a void agreement for finding clients for employment.
No, where is the FIR? Do you have the FIR copy of the original complaint?
Yes,
Complaint which was
Page 61, Annexure E,
page 61.
Annexure E.
Read the FIR.
To the officer in charge, Police Station 2, Mohukchung, Nagaland. Subject complaint letter, FIR against Sri so-and-so, son of Sri so-and-so of so-and-so village computer instructor in the unit higher secondary school, Alijit and Sri Ram Kumar Baldam, second NAD, number 8076. Sir, it is bring to your kind information that the above named 2 persons have promised to help in getting job service in Nagaland Armed Police Department, for which they have charged money from the intending candidates, which in good faith we have contacted the intending candidates and collected the amount and given to them, amounting to rupees 79 lakhs 16,000.
Collected the money from whom?
From their families and their relatives,
Okay.
and they gave also for themselves as well as for those people. Because they were told by the respondent number 1 to spread the word around that if there are any relatives and friends who also want to avail that opportunity, then those persons may also be brought along with the money.
Okay. Okay.
So
Yes,
it
Miss.
was on the instruction of the respondent number 1 that they spread the word around to their family members and friends, close friends.
Okay, you are referring to now this AR 1974, but that case relates to a civil suit
Yes.
under section 65 of the Contract Act, and they are not before this court claiming any compensation under
Yes, sir.
section.
Okay. 14 ACP 452. 14 ACP 452.
Yes.
Page paragraph 11. Paragraph 11.
Yes.
Section
Yeah.
53 of the Contract Act provides that any agreement which is opposed to public policy is not enforceable in a court of law. And as such an agreement is void since the object is unlawful. The person under section 105 CRPC is summary in nature and indeed to provide a speedy remedy to the right. And any order passed under section 105 CRPC by compromise or otherwise cannot be forcefully forced, close the remedy available to the right of the section 18 when there's a void agreement, it cannot be enforced by law.
They are not before for enforcing that agreement. they have come before the court alleging that you have cheated them.
Yes.
You have issued forged appointment orders.
Yes.
So allegations of forgery is there, cheating is there.
Yes, my lord. The only issue is with the contempt of punishment. They are saying that it has to be intense. Now, as I have referred to the IPC under which the appellants, the respondents were convicted. That is the punishment is up which to a maximum of 7 years, which may extend up to 7 years. Though the lower trial court has rightly came to a conclusion that they may be given a punishment of impose a fine of which 1,000 with a simple imprisonment of 2 months, like that. So there's no wrong, because it says it should not, it should be 7 years.
Okay. So the quantum of punishment is within the
Yes,
prescribed limit.
yes.
Okay, but what is your answer to the submission made by the appellant's counsel that the sessions court could not have usurped the jurisdiction without committal of the case to it by the committal court?
My lord, in the impugn order, it has said that he has made a category mention that as there is no regular judicial magistrate posted in Mokcho. In view
So,
of the
Can
not
he do
every
so?
city.
Can he take it up all the, because there is no, because High Court has provided for who will be taking up such cases. There is a notification of the High Court. So going beyond that notification, whether session judge could have taken upon himself the power.
Yes,
What is your submission on that?
in that, my lord, I don't have much to say because it has it was on the wisdom of the learned session judge that he has taken over he is by himself.
Okay. Now the query is whether this appeal can be,
Yes,
if suppose assuming that appeal could not have been preferred by the present appellant, can it be converted into a revision or some other form of?
it has to be either appeal or revision, my lord. If it is under 374, it has to be by the convicts.
Okay.
So, and the court title itself is a criminal appeal.
Okay.
Whether this court can convert it into revision. But since they have filed.
Mr. Sentianger, you will be submitting at 2.
Yes.
Okay. Your submission is over?
I don't have much to say in this case.
Okay.
Only on the 374.
We'll continue with this case at 2.
I want to go back to my time and do something.
Okay. We'll finish the hearing today itself. At 2, we'll take it up again.
With your plans.
Right.
For hearing item number 28,
This matter was, this was, no, this was
item number 19.
19. Yes.
Please, your lordship. This is an appeal under section 173 of Motor Vehicle Act 19 against the judgment and order dated.
Yes, just a minute, just Albert. Step in this with that record. Let me see appeal 3 of 2020. What is your name?
Muadu.
Moa Jumla. Yes.
Appeal is against the judgment in order dated 25/3/2023, passed by the London MSCT Twinsan on MSC case number 11 of 2019. So the London MSCT is passed an order granting rupees 22,55,000 with interest of 9% to be paid within the period of 30 days. So, equipped by this order, the plaintiffs approached this honorable court. So, my lord, the ground is, there are only 3 counts in this appeal. Number 1 is that the learned MST has relied on oral evidence and had come to the conclusion that the business was running a restaurant business and fixing the income of rupees 12,000 per month as a monthly income. So your lordship, to run a business, even to run a pawn shop, we need a permit or some license. But here, in this case, no license, nothing, no documents was produced by this, by the respondent, claimant respondent. And then the court has relied on the oral submission and come to the conclusion that her earning was 12,000 per month. And then the second ground is, this petition was filed under section 166 of Motor Vehicle Act. Here, rash and negligent driving of the driver should be proved. But in the instant test, nothing was submitted. No FIR, no charge sheet was filed, and then no post-mortem report was executed during the trial in the lower court. So that is another ground.
No, second ground is?
No Russian negligence was proved.
Okay, rash and negligence was not proved.
Was under section 166 of MBA, Russian negligence should be proved.
Okay.
And then the third ground is that the learned member had considered all the major children of the dependent of the deceased. And then had come to the conclusion that the deceased had been deducted 1/4 of the deceased for personal expenses. So many of the children are mature, so they are not dependent on the mother income, but the learned member has deducted 1/4 instead of 1/3 toward the personal expenses and the So under the ground, that is the only 3 ground I want before this honorable court.
Anything else? Yes, Mr. Sharma.
May it please the lordship. I have prepared a small case, Mayor, for first of all, I recite the fact of the case, lordship. On 22/1/19 at about 4 PM, the disease riding pillion on the motorbike number AS07M159 driven by her son while going towards Laluk on the way at reaching Gauhati near Shiv Mandir. Suddenly, a stray goat appeared in the road to cross the road. To avoid hitting of the stray goat, the driver of the motorbike applied sharp brake. Due to high speed, failed to control the motorbike, as a result of which the motorbike with heavy jerk ran over a high speed breaker and overturned. Due to sudden application of sharp brake and heavy jerk, the pillion rider fell down from the bike, sustained grievous injuries, and succumbed to her injuries on the way to hospital. The claimant examined 3 witnesses. However, no defense witness examined by the opposite parties. In the whole proceeding, Lordship, no defense witness at all examined by the opposite parties. Lordship, my submission against the allegation of monthly income of the deceased, Lordship. The unrebutable evidence of the claimant, it is specifically mentioned that by profession, the deceased was a housewife as well as running a canteen, wherefrom the deceased used to earn rupees 15,000 per month as her livelihood. Lordship. Even in the cross-examination of the claimant in para 3 of my G's Lordship, the claimant cross-examined by the insurer appellant. To reply the cross-examination of the insurer, the appellant categorically stated that it is correct to say that at the time of death, my mother was 40 years old and was running a restaurant at Naharlagun, Itanagar, wherefrom used to earn 15,000 per month. It is a reaffirmation even in the course of cross-examination by the insurer himself. Further, to reply the cross-examination of the opposite party number 1 and 2, the claimant stated that it is not true that my mother was not earning from her restaurant business. That is the mere suggestion. The income and avocation of the disease remain uncontroverted, and no evidence to the contrary could able to produce by the appellant to disprove the income and restaurant business of the disease. However, the learned member MST considered rupees 12,000 only for assessment of compensation despite the established income. The established income is not 15,000 per month, which is beyond dispute. But however, learned member only considered rupees 12,000. Lordship. And Lordship, in Zambai, widow of Dinkara, Ghorapada and others, ICICI Lombard General Insurance Company Limited, 2022 10 SCC 512. The relevant para 15, wherein the Honorable Supreme Court held that the evidence of the appellant number 1 on affidavit that her husband was getting salary of rupees 12,450 and that he was over 50 years of age, the learned tribunal assessed monthly income of the deceased as rupees 10,000 in absence of proof of salary, which has been approved by the Honorable Supreme Court in terms of judgment passed in National Insurance Company versus Banai City, 2017-16 SEC 680. Lordship, I like to recite another decision which is very relevant. Shiv Shankar M versus Managing Director, Bengaluru Metropolitan Transport Corporation, 2017, 5 SCC 79, particularly para 5 and 6. In para 6, held in absence of any serious dispute on the part of the respondent on the avocation and income, we are of the view that the tribunal and for that matter, the High Court should have accepted the evidence of the appellant. There is no dispute in the court below in regards to the income of my mother and profession of my mother. There is no dispute. So under this principle, the whatever monthly income accepted by the tribunal is true, proper and correct. Therefore, we assess his monthly income as rupees 15,000, and after deducting 1/3 towards his personal expenses, the income will be assessed for the purpose of computation of compensation as rupees 10,000 per month. the income is substituted as rupees 10,000 in place of 6,500 as assessed by the High Court. The compensation will carry interest at the rate of 9% per annum from the date of claim petition before the tribunal. Rest of the award is maintainable. Lordship, by following these principles, even this honorable court also passed the various judgments which are unreported cases. So, leaving aside that, in Kunsuma Begum, Srimati and others versus New India Assurance Company Limited 2001 to SCC 9, the Honorable Supreme Court accepted the evidence of the widow that her husband's income was rupees 1,500 per month in absence of any contrary evidence. Lodged. The said principle was also followed by the Supreme Court in Gurmeet Kaur versus another versus State of Haryana and others 2001 TAC 203, and it is also worthwhile to refer the decision of Madras High Court in the case of Tandin Roadway Corporation versus Sankarmal and others 1998 ACJ 1175, and in Srimati Vilasini Mandal versus National Insurance Company Limited and others 2003 to TAC 435, where not only the above principle was followed, but it was also held that in absence of documentary evidence, oral evidence as to the income, if rejected, the same may cause in a large number of cases severe hardship to the claimant. In reality, Lordship, in large number of cases, the victim of a motor vehicle accident may have kind of occupation in which it will be most impossible for a claimant to produce any documentary evidence in respect of the income of the deceased. If this court would stick on the documentary evidence, it would cause untoward misery and hardship to the claimant. If it is insisted, the oral evidence will not be accepted unless it is corroborated by the documentary evidence, and as such, the court held that in absence of documentary evidence, oral evidence as monthly income can certainly be relied. My submission in regards to the allegation, no rash and negligent driving, no FIR, no postmortem. Lordship, from the available evidence of the claimant and more particularly the evidence of the two eyewitnesses, that is PW1 and 2, it is made clear that the accident dated 20/1/19 was the result of sole rash and negligent driving of the driver of the offending motorbike. Lordship. In examination of PW1, claimant stated that on 22/1/19 at about 4 p.m. by riding pillion in the motorbike number so-and-so driven by my brother Papu Soikia, while my mother was going to Lalu on the way at Kohima, due to rash and negligent driving and high speed of my brother and application of sharp brake to avoid knocking of stray goat, the accident took place. Resultantly, my mother fell down from the bike in the main road and sustained grievous injuries and succumbed to her injuries on the way to hospital. The PW1 cross-examined by the counsel for the insurer, that is very important, Lordship. To reply the cross-examination of the insurer, the PW1 stated that it is correct to say that on 22/1/19, my mother riding on pillion on the motorbike number so-and-so, driven by my brother Papu Soikia going to Lalu on the way at Kohima near Shiv Temple, due to high speed and sudden appearance of stray goat, the bike failed to control and speedily jumped over a high-speed breaker. Due to heavy jerk, my mother fell down from the pillion seat on the road, sustained grievous injuries, and later on succumbed to her injuries on the way to hospital. I denied a suggestion that my brother was not responsible for rash and negligent driving. This is a clear answer in the cross-examination, Lordship, wherefrom it is appeared that the accident was because of careless driving, and for which the motorbike
suddenly jump over a high-speed breaker and overturn on the road. Lordship. Further to reply the cross-examination of the OP number 1 and 2, the PW1 stated that I denied a suggestion that the motorbike number so-and-so was not responsible for rash and negligent driving. It is incorrect to say that my mother was not a pillion rider at the time of accident. It is not incorrect to say that the motorbike ran over a high speed breaker in the turning and failed to control the speed, resultantly due to heavy jerk, the pillion rider thrown out from the pillion seat and sustained grievous injuries. I denied a suggestion that there was no eyewitness to prove the case, whereas the fact remained that on the day of accident, there were so many devotees in the Shiv temple for performing puja, who even helped my mother for getting medical treatment and even informed the concerned police station for needful action. Lordship. In examination of PW2, stated that whereas I am the eyewitness of the accident, this is a very vital witness, Lordship. That at 22/1/19, on the day we the local people of the area performing Shiv Puja at Shiva temple situated in the Gauhati, at about 4 p.m., I have seen that a motorbike number so-and-so was coming from Victoria side with high speed along with a lady pillion rider. In front of the Shiva temple, there is one high-speed breaker. While the motorbike was about to reach the speed breaker, suddenly one stray goat appeared on the road, and due to high speed, the motorbike, to avoid hitting, dragged the motorbike to the wrong side and ran over the high-speed breaker. Due to heavy jerk, while running over the speed breaker, the lady pillion rider fell down from the bike and also the motorbike overturned on the road. The pillion rider lady sustained grievous injuries, and almost all the devotees helping the victim for getting medical assistance. Also among us, one male person had informed the police station. What I have seen is that if the motorbike drove in a moderate speed, there would not be any accident, even sudden appearance of the stray goat. My statement before this court is true and correct. That was the unrebutable evidence of the PW2. Now, Lordship, to reply the cross-examination of the PW1 and 2, opposite party number 1 and 2, the PW2 stated that I denied the suggestion that motorbike was driving carefully and cautiously. It is correct to say that the lady pillion rider fell down from the motorbike due to speedily running over the speed breaker. Further to reply the cross-examination of the insurer, Lordship, the appellant PW2 stated that it is correct to say that the motorbike was driving in a high speed and near Shiv temple to save a stray goat speedily. The motorbike ran over a high speed breaker, and due to heavy jerk, the pillion rider fell down from the pillion seat, and the motorbike also overturned on the road. Resultantly, the pillion rider sustained grievous injuries. That is also appeared clear reaffirmation appeared from the cross-examination of the PW2, which has been done by the insurer, Lordship. Now, another witness, PW3, Lordship. In examination of PW3, who categorically deposed that, whereas I am one of the eyewitness of the accident. That is also another eyewitness, Lordship. On 22/1/19, our village were performing Shiva Puja at Shiv temple at Pukhuriporia. I have seen one motorbike along with a pillion rider was coming from Bikuria side towards Amoguri side. Just nearby the Shiv temple, due to sudden appearance of a stray goat, the motorbike to avoid hitting speedily ran over a high speed breaker just nearby the Shiv temple. Due to sudden and heavy jerk, lady pillion rider fell down from the bike and the motorbike also overturned on the road. If the motorbike drove in a moderate speed, would have easily avoid and cross the speed breaker and avoid the accident. The PW3 was also cross-examined by the opposite party number 1 and 2. To reply the cross-examination of the opposite party number 1 and 2 stated that I deny the suggestion that I am not the eyewitness of the accident, whereas the fact remains that not only me, there was many more eyewitnesses who were present at the temple premises as devotee. I deny the suggestion that I cannot remember the motorbike number, whereas I can say that the offending motorbike number is 07M0159. Further to reply the cross-examination of the insurer, which is very important in this case, Lordship. PW3 categorically stated that it is correct to say that I am one of the eyewitness of the accident dated 22/1/19, which took place at Pukuripuria Shiv Temple near Gauhati. I deny the suggestion that the motorbike was not responsible for rash and negligent driving. In my opinion, the accident was the result of negligence of the driving of the motorbike. This is the clear evidence of the all eyewitnesses as well as the claimant, Lordship. From the unsecond evidence of the PW 1, 2, and 3, documents marked and exhibited such as police report, various medical report, the rash and negligent driving against the driver of the offending motorbike is well established. The respondent claimant respectfully submit that MSC claim is a summary civil proceeding wherein the claimant is not required to prove the case as if like other civil and criminal cases. For satisfaction of this honorable court, the respondent claimant relied upon the following decision of Apex Court, Lordship. In NKP Post Private Limited versus Korunamaya Amal and others, which is reported in the AR 1988 Supreme Court 1354, in para 3 and 4 line, wherein the Honorable Supreme Court held that claimant accident claims tribunal must take a special care to see that innocent victim do not suffer and driver and owner do not escape liability merely because of some doubt here or some obscurity there. Save in plain cases, culpability must be inferred from the circumstances where it is fairly responsible. The court should not succumb to niceties, technicalities, and myetics maybes. Lordship, another decision of the Honorable Supreme Court in this regard, done by widow of Dr. Dinakar, which is reported in the 2002-10 SCC 512. The relevant para 11, wherein the Honorable Supreme Court held that we find that the rule of evidence to seek proof serves in a criminal trial cannot be used while deciding an application under section 166 of the MB Act 1988, which is summary in nature. There is no reason to doubt the veracity of the statement of the appellant number 1 who suffered injuries in the accident. The application under the Act has to be decided on the basis of evidence laid before it and not on the basis of evidence which should have been or would have been laid in a criminal trial. We find that the entire approach of the High Court is clearly not sustainable. Even our own High Court in Saraswati Devnath, Union of India versus Saraswati Devnath, reported in 1995 to GLT 117 in para 6, Honorable Court held, the law is settled that in a claim under Motor Vehicle Act, the evidence should not be scrutinized in a manner as it is done in a civil suit or in a criminal case. In a civil case, the rule is preponderance of probability, and in a criminal case, the rule is proved beyond reasonable doubt. It is not necessary to consider these niceties in a matter of accident claim case in as much as it is summary inquiry. If there is some evidence to arrive at the finding that itself is sufficient, no nicety, doubt, or suspicion should with the tribunal in deciding a motor accident claim cases. Lordship, in Bimla Devi versus Himachal Road Transport Corporation, AIR 2009 Supreme Court 2819. Same also reported in 2009-13 SCC 530 in para 16 to 13 to 16, Lordship. In para 15, court held it is necessary to be borne in mind that strict proof of an accident caused by a particular bus in a particular manner may not be possible to be done by the claimant. The claimant were merely to establish their case on the touchstone of preponderance of probability. The standard of proof beyond reasonable doubt would not have been applied. In Kusumlata and others versus Sadbir and others 2011 3 SCC 646 in para 9, it is well known that in a case relating to motor accident claims, the claimant are not required to prove the case as it is required to be done in a criminal trial. The court must keep this distinction in mind. Allegation, no charge sheet evidence required before criminal court is not required while deciding the MSC cases. Charge sheet is not required to decide any cases. Allegation, no postmortem report to substantiate the death of the claimant has marked and established the death certificate as Exhibit P6, another certificate, Exhibit P7 issued by Gauhati by sustaining the death. The Exhibit P6 and 7 nowhere disputed by the opposite parties or by the appellant in the whole course of proceedings in the court below. And as such, Exhibit P6 and 7 mark and exhibited on consent, hence no objection at this appellate stage, Lordship. That death certificate, both death certificate, one issued by the Gauhati and one issued by the government are not in dispute at all in the court below. There is not even question at all against the authenticity and others of the both certificate. So which is marked and exhibited on consent? When there is no dispute, it is marked and exhibited on consent, Lordship. Now, how this objection now before your Lordship? Now, Lordship, ground number 4. Allegation is 4 major children cannot be dependent on the disease other the father and the minor daughter. According to the appellant, father and minor daughter only dependent of the victim. I would like to satisfy your Lordship by giving the reference of our Honorable Supreme Court. In Monjuri Behera versus Oriental Insurance Company Limited 2007 10 SCC 643 in para 19 held in the impugned judgment, the High Court has correctly drawn a distinction between the right to apply compensation and entitled to compensation. The High Court has rightly held even a married daughter is a legal representative and she is certainly entitled to claim compensation. It was further held on the fact of the present case that married daughter was not dependent on her father. She was living with her husband in her husband's house. Therefore, she was not entitled to claim statutory compensation. According to the High Court, the claimant was not dependent on the father's income, hence she was not entitled to claim compensation on no fault liability. In HDFC Ergo General Insurance Company Limited versus Ritu Pade and others, 2022 2 GLT Meghalaya 1040, para 30, 31, and 32. In para 30, as regard to the entitlement of major, married, and even earning legal representative of the disease victim, the Honorable Supreme Court dealing with a similar issue in the case of National Insurance Company Limited versus Birendra and others, 2020 11 SCC 365 at paragraph 14 was held as follows, Lordship. In 14, it is thus settled by now that legal representative of the disease have a right to apply for compensation. Having said that, it must necessarily follow that even the major married and earning person of the disease being legal representative have a right to apply for compensation and it would be the burden, bound and duty of the tribunal to consider the application irrespective of the fact whether the legal representative concerned was fully dependent on the disease and not to limit the claim towards conventional heads on the lordship. In para 31, lordship, Supreme Court in the case of Manjuri Bera versus Oriental Insurance Company Limited 2007-10 SCC 643 at para 19, while agreeing with the distinction drawn by the High Court between right to apply for compensation and entitlement of compensation, has also observed that the High Court has rightly held that even the married daughter is a legal representative and she is certainly entitled to compensation. In para 32, lordship, held in the light of the above, there can be no doubt that the objection of the appellant as to the dependency of the married daughter of the disease cannot be sustained. According to this court, hold that the dependent of the disease, including the respondent number 1 claimant, are 4 in number, and in this respect, the finding of the tribunal cannot be disturbed. Lordship, maybe a major children, maybe a married daughter, they were entitled for compensation. There is no dispute. Even the rule has already been established by our Honorable Apex Court, lordship. Lordship, now, their allegation is also regarding interest, lordship. That is the ground number 5 of the appellant, lordship. Section 171 of the Motor Vehicle Act provides that where any claim tribunal allow a claim for compensation made under this act, such tribunal may direct that in addition to the amount of compensation, simple interest shall also be paid at such rate and from such date not earlier than the date of making the claim as it may specify in this behalf. Under the provision, awarding of interest is appeared proper, lordship. The respondent claimant relied upon the following decision of our apex court. This is a lordship larger bench decision, 3-judge bench decision. ICICI Lombard General Insurance Company Limited, Ajay Kumar Mahantri and others, 2018 3 SCC para 13. This is a 3-judge bench. Held that claimant shall be entitled to interest 9% per annum from the date of filing of the claim. So another larger bench decision, lordship, as Thangaras versus National Insurance Company Limited 2018 3 SCC 605 para 9, held wherein the larger bench of our Honorable Supreme Court held the claimant is entitled to interest at the rate of 9% per annum, lordship. So another decision of 3-judge bench, lordship, of Honorable Supreme Court in Bhartiben Nayabha Kher and others versus Sadibha Patabha Manke and others, AIR 2018 SC 2728. This is also 3-judge bench decision, lordship. In para 7, Honorable Supreme Court held the claimant is entitled for 7% interest per annum from the date of filing of the claim petition. So this is my humble submission before this Honorable Court. The appeal filed by the appellant cannot stand under test of judicial scrutiny. All the evidence in the court below are well established and there is no dispute at all of the appellant in the court below, and whatever objection raised, ground raised before your lordship, that cannot be stand under test of judicial scrutiny. This is my submission, lordship.
Lordship, I'm for respondent number 6.
Who is respondent number 6?
The owner of the vehicle, motorcycle, lordship.
Owner, you are husband of the deceased.
Yes, your lordship, the owner of the vehicle. Lordship, here I have only one simple prayer that I endorse to what my learned senior counsel has submitted, lordship. And then there's no dispute that accident happened. And during the time of accident, I was possessing a valid, up-to-date insurance policy, lordship. That is my humble prayer.
You are supporting the submissions of appellant
Yes,
or
no, your lordship. The claimant, your lordship.
claimant?
Yes, your lordship.
Okay. Heard. Anybody else?
I'm agreeing on behalf of respondent number 7, Your Lordship.
Who is R7?
Respondent number 7 is the driver of the motor vehicle.
Brother,
Driver.
you are son of
I'm
the,
the son of the plaintiff.
what is your, I forgot your name.
Exactly.
Your name is not there in the cause list.
It's there, Your Lordship.
Item number 30.
28.
Okay. Okay, it is there.
Yes.
What is your submission?
Most of the submission has been, I rely upon the submission of the main claim, Your Lordship. And further that, the time of the accident, I was having a valid license, and as such, since there's a policy, it should be covered by the insurance company. Actually.
Heard, Miss Moa Jungla, learned counsel for the appellant. Also heard Mr. B. N. Sharma, learned counsel for respondent number. Respondent number?
125.
Oh, respondent number 125. Miss Noksum Tila, learned counsel for respondent number 6, as well as Mr. Z. Kulno, appearing for respondent number 7. Hearing concluded, judgment reserved.
Much obliged.
For hearing item number 29.
Yeah.
And for the appellant company, that's. Here in this case, the claimants. Claimant respondent number 1, 2, and 3, Doctor. They filed a claim case registered as MSC. Doctor.
Yes, sir. Yes, claim case number. Yes,
Claim case number 7 of 2019 at Mount Chunk, Doctor. For the death of the deceased in a road traffic accident, Doctor, where he was traveling as a pillion rider on a motorcycle, ridden by respondent number 4, the owner of the motorcycle. The cause of the accident, Lordship, was asserted to be rash and negligent riding of the motorcycle by the owner, Lordship. Lordship, the facts of the case that while riding the motorcycle. The
We'll continue post lunch, after lunch. We'll.
I need the mention of item number 3 in the full shape. But I have a hearing also, fixed matter in possible 2, court number 1 or shape.
23,
No, 33 and 24. The last two items.
23 and 24 have
No,
been.
33 and 34.
33.
Yes, Lordship, if this matter can come out after 2 weeks, Lordship. I have more instruction to issue from the petitioner's Lordship.
Okay, heard Mr. N. Muzoi, learned counsel for the petition. You have informed the
Yes, Lordship, I hope the government will get this one.
who submits that who prays for an adjournment of 2 weeks. He has also submitted that he has informed the learned counsel for the respondent side,
State response,
state respondent.
additional AG.
Considering the submissions made by learned counsel, the prayer is allowed. Let this matter be listed after 2 weeks.
2 weeks. Good luck, sir.
Your indulgence, Lord. I have mentioned item number 31, Lordship. Hearing item number 31, Lordship.
Yes,
With the consent of the other side, Lordship. Lordship, I could not prepare the brief as I'm not well, Lordship.
okay.
So
Heard Mr. V. Devnath, you don't have any objection.
No, Lordship, this matter will fix on 26 March.
Heard Mr. V. Devnath, learned counsel for the appellant who prays for an adjournment on the ground that due to personal difficulty, he could not prepare the case today. Mr. B. N. Sharma, learned counsel for the respondent, concedes to the prayer of the learned counsel for the appellant. Hence, the prayer is allowed. Let this matter be listed on 26th March.
I will.
ये सांप का चेंबर मिल जाएगा।
आपका चैम्बर में
ये सांप मुझे घर भी लेके जाएगा ना।
तो रात डलेगा अभी।
क्या चले? हाँ हाँ। Only one item is left, huh? Only one item. And one is missing.
Yes.
May I please, my lord? In my respectful opinion, this honorable court has the authority, has the power to pass orders under 401 CRC.
401.
Yes, Lordship, I'll be letting my suggestion on that, Lordship. But before that, Lordship, if I may be allowed to read a single paragraph from 2004 to SC 278.
Yes. What is the citation?
2004 12 SC 278. Relevant paragraph is paragraph 9.
Yes.
It is well settled that if an authority has a power under the law merely because while exercising that power, the source of power is not specifically referred to, or a reference is made to a wrong provision of law, that by itself does not vitiate the exercise of power, so long as the power does exist and can be traced to a source available in law. Now, on that same line, Lordship, 2002 9 SCC 509, paragraph 3, I have highlighted the relevant portion. The relevant portion is at page 512. A short sentence. 512. Merely because a wrong provision was quoted by the collector for exercising his power while deleting the name of the applicant from the revenue record would not invalidate the order. If it is shown that such an order could be passed under the other provisions of the Act, which under section 48 of the UP Consolidation of Holdings Act. Now, Lordship, if I may be allowed to place a single citation, Lordship.
Yes.
On the powers of this honorable court under section 401 of the Criminal Law of the Court. Lordship, now, even if a conviction has been reported by the Indian order, Lordship, it amounts to acquittal. Because 79 lakhs, 16,000 has, I have been cheated out of that account and then imposing a fine of 1,000 rupees, Lordship, without any sentence, Lordship, of imprisonment.
No, but it is not acquittal. It is conviction with
Yes,
a.
but it is the same as acquittal of it.
No, that is as per your assessment.
Yes. Now, which is why I am coming before this honorable court saying that there is great miscarriage of justice. Now, Lordship, the single citation that I want to refer to is AIR 1997, Supreme Court 2485. Here, 5 or 6 judgments of the Honorable Supreme Court has also been.
What is AIR 1997?
SC 2485.
You have given that.
Yes, Lordship, I have submitted the proof.
Okay, yes.
It's a short judgment of 6 paragraphs, Lordship. If I may be allowed to.
What is a relevant portion you may read? This is regarding what matter? 401.
401, Lordship. Here, Lordship, the second court, that is the trial court, acquitted the accused passing on the investigation report.
Okay.
So the High Court interfered under 401, and that was challenged, Lordship, before the Honorable Supreme Court. The Supreme Court held that the High Court was right in exercising its jurisdiction under 401.
Which is the relevant paragraph?
Paragraph. Three and 5, Lordship. Primarily. Three, Lordship.
Yes.
In accepting the judgment of the High Court, Mr. Lalit, the learned counsel appearing for the appellant submitted that the High Court approved revisional jurisdiction under section 401 CRPC. In that, it addressed the entire evidence from its own point of view and reached inferences contrary to those of the trial court on almost every point, which was legally impermissible. In support of his contention, he relied upon the judgments of this court in Jinwaswamy versus State of Andhra Pradesh, Mahindra Pratap versus Sarju Singh, Ketra Pasi versus State of Orissa, and V.N.G. Raju versus P.P. Apatu, wherein the scope and extent of the revisional jurisdiction of the High Court in dealing with an order of acquittal had been dealt with. In Jinwaswamy, this court held that though it was open to the High Court to set aside an order of acquittal, even at the instance of the private party, the revisional jurisdiction should be exercised only in exceptional cases where there was some clear defect in the procedure or there was a manifest error on a point of law, and consequently, there had been a flagrant miscarriage of justice. This court pointed out that it was not possible to lay down the criteria for determining such exceptional cases which would cover all the contingencies, but indicated some cases which would justify the High Court to interfere with an order of acquittal in revision. The cases so indicated are where the trial court has no jurisdiction to try the case but still acquitted the accused, or where the trial court has wrongly shut out evidence which the prosecution wished to produce, or where the appeal court has wrongly held evidences which was admitted by the trial court as not admissible, or where material evidence has been overlooked either by the trial court or by the appeal court, or where the acquittal is based on the compounding of an offense which is invalid under law. In the other cases referred to above, this court reiterated the principle laid down in Jinwaswamy and observed that the revisional jurisdiction, when invoked by a private complainant against an order of acquittal, ought not to be exercised lightly, and that would be exercised only in exceptional cases where the interest of public justice required interference for the correction of manifest illegality or the prevention of a gross miscarriage of justice. Verified. From the conspectus of the above decisions, it follows that the revisional powers of the High Court, while sitting in judgment over an order of acquittal, should not be exercised unless there exists a manifest illegality in the judgment or order of acquittal, or there is grave miscarriage of justice. Read in the context of the above principle of law, we have no hesitation in concluding that the judgment of the trial court in the instant case is patently wrong and it has caused grave miscarriage of justice. The High Court was therefore fully justified in setting aside the order of acquittal. From the judgment of the trial court, we find that one of the grounds that largely weighed down with it for acquitting the appellants was that an inspector of CID, who had taken up the investigation of the case and was examined by the defense, TW3, testified that during his investigation, he found that the story as made out by the prosecution was not true, and on the contrary, the plea of the accused appellants that in the night of the incident at the Kohima with murder took place in the house of by unknown criminals, and the appellants were implicated falsely was proved. It is right that result of investigation can never be legal evidence, and this court in Vijayendra versus State of Delhi made the following comments while dealing with this issue. If I may jump to the next page, Lordship. The High Court was therefore fully justified in commenting about the trial court's impermissible and undue reliance upon the evidence of TW3, and for that matter, the result of his investigation. Incidentally, it may be mentioned that ignoring the report of the investigation submitted by the inspector, the magistrate took cognizance of the offences alleged against the appellants and committed the case to the Court of Session. There are other patent infirmities in the judgment and the trial court to which the High Court has adverted, but in case any reason given by us for this comment of ours creates an unconscious impression upon the trial court, we refrain from doing so. We therefore find no merit in this appeal and dismiss it. Before parting with this judgment, we would like to observe that in complying with the directions of the High Court, the trial court should not in any way be influenced by any observations made by the High Court touching the merits of the case. So, Lordship, where there is grave miscarriage of justice,
Yes.
This court under 401 can interfere, Lordship, with the orders passed by the trial court below. Lordship, at the cost of repetition, Lordship, there is no capital order. And sections cannot take up cases that is exclusively under the CRPC, triable by the magistrate. As such, my humble prayer before this honorable court is that the matter may be sent back to Lordship. And the trial may commence from the stage it had stopped before the magistrate's court moved to.
Yes, Mr. Longkumer, anything?
The judgments which Madam Friend has referred, that is 2004 SCC and 2002 of SCC, that's regarding the order passed under wrong provision of law. But the key question here is the has been referred under 374, and then section 372, 397, and 401 are revisional jurisdiction. And then, but the AIR 1987, which my legal friend has referred, was power of the High Court to exercise revisional power in order of acquittal. Here, it's not about acquittal, it's about conviction. Yes, if it is a revision, this honorable court can interfere. But here, whether appeal or revision will have, because appeal as well as revision cannot. These are two different provisions. So, if I'm correct, my lord, you have sort of clarification regarding whether section appeal can convert it into revision. This is what, if I'm right, correct. This is what this honorable court has.
Yes. What is your response to that?
So like, since it is an appeal, and then appeal under 374 is to be preferred by convicted persons only, not by any other persons.
So in the present form, it does not,
Yes.
it is not maintainable.
It's not maintainable. That is my humble submission.
Okay. Heard Mr. Senti Ange, learned counsel for the appellant. Also heard Mr. N. Longkumer, learned counsel for the respondent number. Anybody appearing for state? Okay, you are respondent number?
1 and 2.
Respondent number 1 and 2. Hearing concluded, judgment reserved. Albert. If these. In some cases, I have marked. Keep all lines, fine. Just on the next item. Yes, Mr. Devnath.
Item number 29.
Number 1, 2, and 3. Finally, claim is registered as MSCT 7 of 2019 under section 166, relating section 140 of the MBA for the learned member for the death or to the sea in a road traffic accident on 21/2019, traveling as a pillion rider on a motorcycle.
Yes.
And the cause of the accident was ascertained to be rash and negligent riding of the rider of the motorcycle. That is, respondent number 4 happens to be the owner of the motorcycle. Now, Lordship. The
Owner was the driver.
owner himself was the rider of the motorcycle.
Okay.
Now, Lordship, the insurance policy exhibited by the claimant in the claim petition happens to be the liability only policy, wherein the premium for the pillion rider was not purchased by the owner of the motorcycle. And in such scenario, Lordship, the insurance company has no legal liability
upon the incumbent upon the claim to indemnify the owner. However, the learned tribunal has overlooked this vital aspect and has rendered the impugned award and asked the insurance company to satisfy the award clause.
Okay, the pillion rider was not covered.
Not covered. As per the policy, as it is a act only policy, and there are cabinet of decisions of the Honorable Supreme Court as well as our Gauhati High Court, that in act only policy, if the premium was not purchased by the owner of the vehicle for the pillion rider specifically, he shall not be covered. However, it is covered in comprehensive policy, but not in the act only policy. And it is an aggregate fact that the policy is act only policy. More so, Lordship, the deceased, the claimants, they could not prove the income of the deceased, Lordship. And in absence of the proof of the income, Lordship, the learned tribunal ought to have taken the help of the second schedule of the MV Act, and while computing the compensation, ought to have taken the notional income as 15,000. However, overlooking all the vital aspect, Lordship, has computed the compensation and has rendered the impugned award.
Okay.
Even Lordship, at the time of his death, he was a bachelor. And as per the decision rendered in Sarla Verma, Lordship, only the mother of the deceased can be the claimant. But here it is not the mother, but the father.
Where is that decision? That only.
Lordship, it is 2009 SCC 121.
Sarla Verma's.
Sarla Verma.
Read out that portion where it is mentioned that only mother can.
I'm very sorry, Lordship, I'm not carrying it.
No, which para you are relying that only mother can be the.
Lordship.
Your submission is that in case of a bachelor
Lordship.
death, only mother can be the claimant. Where is that law?
Lordship.
Okay, you make your submissions, you can show it to me later on also.
Lordship.
That court relevant paragraph, which
Lordship.
from Sarla Verma's case, the para on which you are relying
Lordship.
in to support your submission, you quote that paragraph later on. Okay.
Lordship, I will provide you to refer the authorities, Lordship, in terms of the policy. Lordship.
Yes.
Lordship, it is 8, Lordship, 7.
428, page number 428.
2008.
7 and 6, 428.
Para. Paragraph.
Paragraph 11, paragraph 17, 18 and 25.
What it says.
Actually, the operative part is at 433 page number. It will be on the lordship right hand side.
Yes.
Lordship. This court, in a Ketna decision, has categorically held that a gratuitous passenger in a goods carriage could not be covered by a contract of insurance entered into by and between the insurer and the owner of the vehicle in terms of section 147 of the Act.
This was not a goods carrier.
Not goods carrier. However, the Supreme Court in Ketna decision has held that the pillion driver cannot be a third party. Sure. Yes, I'm coming to it.
Okay.
The next paragraph, Lordship. The division bench of this court in United India versus Tilak Singh extended the same principle to all the categories of the vehicles, also stating as under. In our view, although the observations made in Asharani case were in connection with carrying passengers in a goods vehicle, the same would apply with equal force to gratuitous passenger in any other vehicle also. Thus, we must uphold the contention of the appellant insurance company that it owed no liability towards the injuries suffered by the deceased so-and-so who was a pillion rider, as the insurance policy was a statutory policy, and hence it did not cover the risk of death of or bodily injury to a gratuitous passenger. Actually, return the page to page number 435, paragraph 25.
Yes.
The law which emerges from the same decision is, number one, the liability of the insurance company in a case of this nature is not extended to a pillion riders of the motor vehicle, unless the requisite amount of premium is paid for covering his or her risk. Number two, the legal obligation arising under section 147 of the Act cannot be extended to an injury or death of the owner of the vehicle or the pillion rider. Number three, the pillion rider in a two-wheeler was not to be treated as a third party. Number third party when the accident has taken place owing to rash and negligent riding of the scooter and not on the part of the driver of another vehicle. And in this case, Lordship, at hand, there was no other vehicle involved when the accident occurred. It was completely the rash and negligent riding of the owner. Lordship, next ruling I would like to refer is 2009, 17 SCC 301.
Zero.
Page 301, Lordship. Paragraph, Lordship, 11.
Yes.
Lordship. Paragraph 11.
Paragraph.
11.
Yes.
Left hand side bottom.
Yes.
Having regard to the evidence on records, we are satisfied that the alteration of the respondent conviction by the High Court from section 307. Paragraph 11, Lordship.
2009 17 SCC 301.
301, Lordship, it was my, yes, paragraph 11. In view of above, what has been stated by this court in Asharani and Tilak Singh cases, the order of the High Court is clearly unsustainable and is set aside and the amnesty is restored, Lordship. Lordship, the note
In this case, it's very clear, Lordship, if I may be permitted to read, Lordship.
Yes.
Motor Vehicles Act 1988, sections 147 and 166. Third party risk, death of a pillion rider, liability of insurer to pay compensation, deceased being a pillion rider and also executor's passenger, hence not a third party. Reiterated cannot claim compensation from insurance company. Asharani case 2003 to SCC 223 and Tilak Singh case 2006 4 SCC 404 follow. Lordship. One more decision, Lordship. It's 2013, 1 SCC 731. In this judgment, Lordship, the statutory authority of the insurance company, that is IRDA, has categorically stated in their regulatory policy dated 16/11/2009 and 3/12/2009 that when insurance company can be held liable and when not. Lordship.
Yes.
Lordship, very sorry, I just forgot to.
No, you read from.
Lordship. Section 146, 147, clause 1 and 166, owner or creditor's passenger traveling in a motor vehicle, meeting with accident, liability of insurer, managing director traveling in a company-owned vehicle, vehicle insured by company, insurer liable to pay compensation in case of comprehensive/package policy, but not in case of act policy. Circulars of statutory regulatory authorities, presently IRDA, dated 16/11/2009 and 3/12/2009 taken into consideration. However, whether policy in question in the incident case describing itself to be comprehensive policy was really a package policy, was it to be determined by interpretation of entire policy, matter remitted to tribunal to determine the said issue and grant relief based on the said determination. Even in this authority also, it is clear that the insurance company can be held liable if the policy is comprehensive.
In the instant case, on what basis you are saying that it was act only policy?
The policy itself says it is act policy. Only for to take note, ICR.
Albert tells you. Yes.
Otherwise, Lordship, it is, I have also annexed it in my
The policy,
appeal memo.
policy.
Appeal memo, yes, internal page number 19 to 21.
Yes.
Lordship, at the top, it is clearly mentioned. Motor insurance certificate from policy schedule, motorized two-wheelers
liability on the policy, zone B, lordship. And if your lordship may turn at page 20, lordship, the liability part on the right hand side, it is clearly mentioned, basic TP cover, basic TP total at PA for owner and driver. There is no extra premium paid for pillion rider also. And the Honorable Supreme Court is very clear that without paying premium of pillion rider cannot be covered under Act on Policy.
What is this basic TP cover?
Basic TP lordship should be third party cover.
Basic third party cover.
Or it can be total premium. Third party.
And pillion rider is not a third party.
Not a third party.
Do you have authority?
Yes. Lordship, the first decision, 2008. If I may again read, lordship.
That portion, read it.
Yeah. Section 147, pillion rider on two-wheeler, if covered by statutory policy issued under section 147. If a third party under section 147 held, insurer is not liable to pay compensation in respect of a pillion rider in the terms of statutory cover mandated by section 147. When the accident has taken place owing to rash and negligent driving of the motor vehicle carrying the pillion rider concerned, such a pillion rider is not to be treated as a third party.
Okay.
Section 147, such a pillion rider covered only in the case additional cover is purchased under the contract of insurance. The legal obligation arising under section 147 cannot be extended to an injury or death of the owner of the vehicle or a pillion rider traveling thereon. Then it has also described who can be termed as a creditor's passenger and who can be termed as a third party.
In the said judgment.
In the same authority also.
Okay.
I mean,
Yes, read it.
the deceased was traveling as a pillion rider on a scooter. She fell down from the scooter and succumbed to the injuries sustained by her. In regard to the said accident, a claim petition was filed before the MSCT tribunal. MSCT, the appellant insurer, in its written statement, inter alia raised a contention that she being a pillion rider and thus a gratuitous passenger, the insurance policy did not cover the risk of injury or death of such a passenger, and thus it was not liable to reimburse the owner of the scooter thereof. By reason of the impugned award, the tribunal inter alia found that the accident had taken place due to rash and negligent riding of the scooter by respondent number 1 to the claim petition. As regards liability of the appellant insurer, it was held that as the existence of the insurance policy in respect of the offending scooter was admitted, it was also liable. The High Court dismissed the appeal of the insurance company thereagainst. Hence, the appellant was before the Supreme Court thereagainst by special leave. The question that arose before the Supreme Court was whether a pillion rider on a scooter would be a third party within the meaning of section 147 of the Motor Vehicles Act 1988. Answering the question in the negative and allowing the appeal, the Supreme Court held a distinction has to be made between a contract of insurance in regard to a third party and the owner or the driver of a vehicle. In terms of section 147 of the Act, a contract of insurance must be taken by the owners of the vehicle only in regard to reimbursement of the claim to a third party. Section 147 is imperative in nature. When, however, an owner of a vehicle intends to cover himself from other risks, it is permissible to enter into a contract of insurance in which even the insurer would be bound to reimburse the owner of the vehicle strictly in the terms In terms thereof, the liability of the insurer to reimburse the owner in respect of a claim made by the third party, thus is statutory, whereas the other claimants are not.
Okay, others are contractual.
Thus, Lordship, the other authority I'd like to place before Lordship. Is High Court of Chhattisgarh Lordship. I have provided the judgment copy for your Lordship. There are 4 to 11 Lordship.
Yes,
If I may read Lordship.
yes.
It is an admitted fact that on so-and-so deceased so-and-so along with her husband was returning from so-and-so on a motorcycle bearing registration number so-and-so, which was being driven by her husband in rash and negligent manner, due to which so-and-so had fallen down and she received previous injuries and died on the spot. The insurance company, respondent number 2 herein, has specifically submitted in the written statement that the policy did not cover the pillion rider. Hence, there is no liability against the insurance company. Paragraph 5. It is now well established by various pronouncement of the Honorable Supreme Court that the insurance company would not be liable to pay compensation to the pillion rider. In the matter of General Manager United Insurance Company versus M. Lakshmi, it was
This
held that-
you have read. Lakshmi, you have read.
No, I have not read it.
Tilak, okay.
I'll come to that. It was held that in the event of an accidental death of a pillion rider of a scooter, being a gratuitous passenger, insurance company would not be liable to pay compensation. Number 7, in the matter of Oriental Insurance Company versus Sudhakaran and others, the following has been held in paragraph 19. The law which emerges from the said decision is, number 1, the liability of the insurance company in a case of this nature is not extended to a pillion rider of the motor vehicle unless the requisite amount of premium is paid for covering his/her risk. Number 2, legal obligation arising under section 147 of the Act cannot be extended to an injury or death of the owner of vehicle or the pillion rider. Number 3, the pillion rider in a two-wheeler was not to be treated as a third party when the accident has taken place owing to rash and negligent riding of the scooter and not on the part of the driver of another vehicle. This I have read, the 2008 judgment. Coming to paragraph 8 also. In matter of United Insurance Company versus Tilak Singh, it was held that, in our view, although the observations made in Asharani's case were in connection with carrying passengers in a goods vehicle, the
This-
same would apply with equal force to.
This you have read in.
Yes, yes, that also was read. Now, in paragraph 9, apart from the above, this court in the matter of Oriental Insurance Company versus Kamta Prasad Sahu also reiterated the settled legal position that the pillion rider traveling on a two-wheeler is not entitled to get any compensation or coverage under the Act only policy. That is, policy issued strictly to meet the requirement under section 147 of the Act. It is also settled law that by virtue of the relevant circulars notification issued by the IRD in the year 2009, the scope of which has already been discussed and explained by the Honorable Supreme Court on many a time, that the position is different if the policy is a comprehensive policy, not being an Act only policy. Number 10, in view of the above authoritative pronouncements of the Honorable Supreme Court that an occupant, inmate, passenger in a vehicle is not a third party, the finding recorded by the tribunal that the insurance policy issued does not cover the risk of death of the deceased, and therefore the insurance company is not liable to pay compensation, just and proper. Number 11, as the insurance company has rightly been exonerated from the liability in the facts and circumstances of the case, the finding recorded by the tribunal regarding quantum is not liable to be interfered with, as the claim was passed against the father of the appellants. Otherwise also, considering the facts that the calculation has been done by the tribunal based upon judicial pronouncement given by the Honorable Supreme Court in the recent past, hence this court does not find any perversity or illegality committed by the tribunal while exonerating the insurance company from the liability. Accordingly, the appeal fails.
No, Lordship, here they have discussed about the notifications issued by the IRD, Lordship. I would like to take a Lordship to 2013 1 SCC 731.
Two thousand 13.
1 SCC 731.
Yes.
Lordship. It was held that an act.
Paragraph.
Lordship, paragraph 10, 22, 24, 26.
Yes.
Lordship. As per the command of section 146 of the Act, the owner of a vehicle is obliged to obtain an insurance for the vehicle to cover the third party risk. Section 147 deals with the requirements of policies and limits of liability. Section 147(1), which is relevant for the present purpose, is reproduced below. Number 1, in order to comply with the requirements of this chapter, a policy of insurance must be a policy which, number A, is issued by a person who is an authorized insurer, and number B, insures the person or classes of persons specified in the policy to the extent specified in subsection 2. Number 1, against any liability which may be incurred by him in respect of death of or bodily injury to any person, including owner of the goods or his authorized representative carried in the vehicle, or damage to any property of a third party caused by or arising out of the use of the vehicle in a public place. Number 2, against death or bodily injury to any passenger of a public service vehicle caused by or arising out of the use of the vehicle in a public place, provided that a policy shall not be required to cover liability in respect of the death arising out of and in the course of his employment of the employee of a person insured by the policy, or in respect of bodily injury sustained by such an employee arising out of and in the course of his employment, other than a liability arising under the Workmen's Compensation Act in respect of the death or bodily injury to such employee. Engaged in driving the vehicle, or if it is a public service vehicle, engaged as a conductor of the vehicle, or in examining the tickets, or if it is a goods carriage vehicle, being carried in the vehicle, or to cover any contractual liability. Lordship, paragraph number 22, Lordship, page number 740, 740.
Yes.
This is the circular of the IRD. The relevant portion of the circular which has been reproduced by the High Court is as follows. Reference: liability of insurance companies in respect of occupants of a private car and pillion rider on a two-wheeler under the standard.
Which is the portion which concerns you?
Lordship, paragraph 22, Lordship.
Yes.
It is the circular, it has been distinguished as the when insurance company can be held liable and when not, Lordship. Liability of insurance companies in respect of occupants of a private car and a pillion rider on a two-wheeler under the standard motor package policy, also called comprehensive policy. Inferior attention is drawn to wordings of section 2, clause 1, 2 of the standard motor package policy, also called the comprehensive policy for private car and two-wheeler under the erstwhile Indian Motor Tariff IMT. For convenience, the relevant provisions are reproduced hereunder. Section 2, liability to third parties. Subject to the limit of liabilities as laid down in Schedule Here 2, the company will indemnify the insured in the event of an accident caused by or arising out of the use of the insured vehicle against all sums which the insured shall become legally liable to pay in respect of
death or bodily injury to any person, including occupants, carried in the vehicle, provided such occupants are not carried for hire or reward, but except so far as it is necessary to meet the requirements of the Motor Vehicles Act, the company shall not be liable where such death or injury arises out of and in the course of employment of such person by the insured. It is further brought to the attention of the insurer that the above provisions are in the line with the following circulars earlier issued by the TAC on the subject. Circular MP1 of 1978 dated so and so. Number 2, regarding pillion riders on a two-wheeler effective from the date of the circular. The above circulars make it clear that insured's liability in respect of occupant carrying a private car and a pillion rider on a two-wheeler is covered under standard motor package policy, that is comprehensive policy laws. A copy of each of the above circulars is enclosed for ready reference. May turn to page number 744, paragraph 26.
Yes.
In view of the aforesaid factual position, there is no scintilla of doubt that a comprehensive package policy would cover the liability of the insurer for payment of compensation for the occupant in a car. There is no cavil that an act policy stands on a different footing from a comprehensive package policy. As the circulars have made the position very clear, and IRDA, which is presently the statutory authority, has commanded the insurance companies, stating that a comprehensive package policy covers the liability. There cannot be any dispute in that regard. We may hasten to clarify that the earlier pronouncements were rendered in respect of the act policy, which admittedly cannot cover a third-party risk of an occupant in a car. But if the policy is a comprehensive package policy, liability would be covered. These aspects were not noticed in Bhagyalakshmi, and therefore the matter was referred to a larger bench. We are disposed to think that there is no necessity to refer the present matter to a larger bench, as IRDA, which is presently the statutory authority, has clarified the position by issuing circular, which has been reproduced in the judgment by the Delhi High Court, and we have also reproduced the same. These are the two circulars, Lordship, which have distinguished that when insurance company can be made liable to compensate the payments in terms of injury or death, and when not, Lordship. Another authority, Lordship, that M. Lakshmi.
Yes.
Lordship, I'm reading from paragraph number 3, internal page number 2.
Yes.
Lordship, to save the time of the honorable post, I am reading from the bottom, Lordship, fourth line, Lordship, from fourth line, starting from it. Paragraph 3, from the bottom is the fourth line, Lordship.
Yes.
It was pointed out, as the Lordship got.
Yes.
It was pointed out that admittedly the policy of insurance was an act policy, and the deceased was a pillion rider and also gratuitous passenger, and hence not a third party, and he cannot take compensation from insurance company which insured the vehicle. Learned additional special judge for so and so, who adjudicated the claim petition, held that the policy was an act policy and act policy in respect of the scooter on the date of accident. Therefore, the insurer had no liability. It was categorically held that unless the policy in question covers even a gratuitous passenger, such person who met with an accident while going in the vehicle in question and received injuries or his legal heirs in case of his death following such accident cannot proceed against the concerned insurance company for any compensation. Compensation payable was fixed at so and so and so. It was held that sum was payable to be realized from the insured and not from the present appellant. It was the finding of the tribunal bench. An appeal was preferred by the claimant before the High Court, which by the impugned judgment relying on a circular of the Tariff Advisory Committee held that the liability of the insurer was there. The appeal was accordingly allowed. Learned counsel for the appellant submitted that the court has misread the circular of the Tariff Advisory Committee dated 2/6/1986. The same referred to compensation payable to a pillion rider in case of comprehensive policy. Clarification circular has no relevance so far as Act policy cases are concerned and it related to only comprehensive policy. Learned counsel for respondent so and so, on the other hand, supported the judgment of the High Court. There is no dispute that the circular dated 2/6/1986 referred to the comprehensive policy. It categorically states that standard form of motorcycle should cover liability to pillion passengers in case of comprehensive policy, as noted by the MSCP policy in the instant case was an Act policy. Thereafter, Lordship, I have read the relevant portion of the Asharani and cited previously, even Tilak Singh and Lordship. Paragraph 9, it says that in view of what has been stated by this court in Asharani and Tilak Singh cases to Prague, order of the High Court is clearly unsustainable and is set aside, and that of the MSCP is restored. Then one more authority lordship is AIR 2020.
Yeah, 2020.
Lordship, AIR 2023 AKR 572. This AIR online lordship. 2020 KAR 1 post.
Karnataka. What is the citation? Repeat again.
Lordship, it is AIR online 2020 KAR 1468. Parties in the case are Oriental Insurance Company Limited versus Shri K.M. Harish Kumar.
No, but this judgment is different. You know. Albert.
Yes. Yeah.
Yes. Page number.
I have supplied the copy. It was my copy.
Oh, okay. Okay, you. But I will need one photocopy.
Lordship.
Give it to.
Lordship, I'm sorry, if I may read it for your lordship.
Yes.
Paragraph 21 of the judgment, it says that the apex court also discussed with regard to the pillion rider will become a gratuitous passenger and he cannot be a third party. Insurance policy did not cover the risk of injury or death of such a passenger, and thus it was not liable to reimburse the owner of the vehicle. Apex Court has framed a question as to whether a pillion rider on a scooter would be a third party within the meaning of section 147 of the MVM, and held that the pillion rider is not a third party. Learned Counsel would submit that the Apex Court in the case of United India versus Tilak Singh Supra extended the same principles to the other categories of vehicles also. In this regard, the court would like to extract the relevant paragraph number 18 and 21 as hereunder.
Skip Tilak
Okay.
Singh.
Paragraph number 21 also. Paragraph 24 of the judgment. On perusal of the principles laid down in the judgment in Tilak Singh, it is clear that the insurance company is not liable to pay the compensation to the pillion rider, and the policy was a statutory policy. And the same did not cover the risk of death or bodily injury to the creditor's passenger. Further, the learned counsel who submitted the Apex Court in the case of so-and-so has held that the liability of insurer to third party, that is creditor's passenger, policy does not cover liability of creditor's passenger who are not carried for hire or reward. Terms and conditions of comprehensive policy relating to private cars cannot apply to third party policy. In absence of terms and conditions governing third party policy, it cannot be accepted that it covers liability of the occupants of the vehicle, private car, insurance company not liable to reimburse the owner of the vehicle. The next lordship. 27. On perusal of the principles laid down in the judgment, it is clear that the policy is a third party policy and not the comprehensive policy, and the third party policy does not cover liability to creditor's passenger who is not carried for hire or reward. The court would like to refer the judgment of the Apex Court in the case of National Insurance Company versus Balakrishnan. It is the 2013, the IRDA circulars where it is mentioned. In this case, the Apex Court held that if specific premium is not paid in respect of pillion rider, the Act policy liability is only in respect of the liability policy, and the same does not cover the risk of pillion rider. The Apex Court in this judgment, referring to section 147 clause 1 of the Act in respect of the private vehicle, if any person traveled in the private vehicle, held that the risk of a passenger in a private car is covered under comprehensive package policy, and the insurance company is liable to third party risk of an occupant of a private car is not covered under an Act policy. Hence, it is clear that the risk of an occupant of a private car or pillion rider is not covered under an Act policy unless specific premium is paid in respect of the pillion rider, and further held that the Act policy is only in respect
Actually,
of
what is held in Asharani is followed in
every case.
every case.
Yes.
In this case also same.
In this case also.
Okay, that is your submission.
Yes.
That in
In
this,
short, lordship, it
in
is
this case, the policy was only
only
covering
policy.
Act policy, that
And
is,
no- no-
only third party, and owner was covered
Only owner.
on extra premium,
No extra premium paid for
pillion rider,
for coverage of the pillion rider.
pillion rider.
Pillion
Therefore,
rider cannot be termed as a third party.
therefore, pillion rider would be regarded as a gratuitous passenger.
And he is not covered.
Insurance company is not liable.
Not liable.
That is your submission.
Yes. I'm not taking lordship's time. In the same judgment, in Union appeal.
It's not my time, it's your time.
Lordship. In this case also, lordship, this Asharani's case and Sudhakaran case, that is in 2008, lordship.
Same thing is
Yes, in
again,
the same line, it was decided, lordship,
okay.
that in Act policy, pillion rider is not covered if premium was not paid.
Mainly you are relying upon Asharani, Tilak Singh and that IRDA judgment of 2013.
Yes.
Where clarifications were given by IRDA.
Yes, as well as Sudhakaran, that is 2008 lordship. 2008, 7 SCC.
Yes, 2008, 7 SCC. That is Sudhakar.
Yes, Sudhakaran. 2008, 7 SCC, 428, Sudhakaran lordship.
And your submission that mother is not entitled.
Lordship, in the course of the proceedings, lordship, I may be allowed to give the paragraph.
Okay. Yes, Mr. Sharma.
Very favorable. So I will declare this.
You have heard his submission.
Yes.
He's relying on mainly two
Yes, Lordship, regarding that, their
gratuitous,
allegation is
that your,
filing of lodging of FIR delay also that is there according to his allegations. So I.
that he's not pressing it.
No, I am not pressing, all right.
It might be in the,
The main issue is regarding the policy particulars, policy liability. Lordship, whatever submission raised before your lordship now, that has not been canvassed before the court. Yes, lordship. That has not been canvassed at all in the court. No policy particulars marked and exhibited before the court stating that they have a limited liability. That has not been done at all. Not any question put forward to the claimant in regards to their liability and others. Lordship, in this regard, I'd like to refer the cross-examination portion of the claimant PW1 in the trial court record.
yes,
Cross-examination of the PW1 by the insurer lordship. That is the more important. The question of insurer is, the answer is, my name is Vinaya. Cross-examination of the insurer lordship. PW1.
yes.
Yes, lordship. I am only residing the cross-examination part done by the insurer. My name is Govind Bhuya. It is correct to say that on 21/19, my son was riding pillion on the motorbike number so-and-so, driven by the opposite party number 1, returning from Pothalipahar towards our residence. It is correct to say that it was evening around 6 PM at Pothalipahar missing ground. One portion of the road was blocked by a herd of cows and were running everywhere on the road aggressively owing to their mating time. The motorbike was driving fast. To avoid hitting of the aggressive cows, the motorbike rider applied sharp brake. Resultantly, my son was thrown out from the pillion seat from few feet distance and sustained grievous injuries. It is correct to say that my son was not succumbed to his injuries on 29/19 while taking treatment. It is correct to say that I have not spent altogether, incorrect to say that I have not spent altogether rupees 3,90,000 as medical expenditures. So that is the only cross-examination done by the insurer before the court below. Not a single question asked before the court below or that their liability is limited.
But that is a question of law.
Yes, Lord, sir. That is the question of law. Maybe question of law that has to be canvassed before the trial court, Lordship. If it is not done, how court will know? Bound them? No. This is my term for submission. So, bound them duty cast upon the insurer to show that their liability is limited. That has not been done in the court below. They have not produced any rebuttal evidence in the court below, despite opportunity granted. No rebuttal evidence produced at all in the court below, Lordship. Regarding this, I would like to recite one decision. National Insurance Company Limited versus Sangita Sonowal Gogoi. That case has been decided by your Lordship before 3 months by sitting in this bench, Lordship, wherein it has been clearly decided that who is third party. So the fact is that the driver of the tractor was died while he was driving. The allegation of the company is that driver of the tractor was not a third party and no compensation can be paid in his favor. A similar fact is in this case.
In this case, the pillion rider, right?
He is a pillion rider, there he was a driver. According to the company, driver cannot be treated as a third party. So your lordship was pleased to held that in the policy, insurance is one party and the owner is second party. A first party, insurance is second party, rest all are third party. That was the decision of your lordship decided in National Insurance Company Limited versus Sangeeta Sunwal and others, which has been decided by your lordship before 2-3 months ago. Now, lordship, if the liability
You
of the,
give that judgment.
I can give it tomorrow, lordship.
Okay.
Yes, lordship. Lordship, if the liability of the company is insurance, they have to raise such objection before the court below, and their duty is to mark and exhibit their insurance policy along with the policy bond. That has not been done at all. Only photocopy of the policy, though it may be exhibited by the claimant, that cannot help the insurance company here in lordship. That is their duty to produce before your lordship. And on the other hand, lordship, insurance policy mark and exhibited as E12 in the court below, wherein it is categorically mentioned that policy was issued for 1+1. One owner, 1 billion. That is the really mentioned in the insurance policy. There is the exhibit E12 in the court below.
Where it is mentioned?
Lordship, in the trial court record, in the
No, you go to the policy.
policy, in the claim petition policy serial number 24, exhibit P12, lordship.
Where?
In the LCR.
Okay.
Lordship.
Now, which portion of the policy you read?
Policy, lordship, in the written seating capacity including driver 1+1.
Where?
It is in the middle portion of the policy, lordship.
Page 1 or page 2?
Page 24, lordship.
No, first page of the policy or second page?
First page of the policy, lordship.
This is the particulars of the vehicle.
Yeah, this is the particulars of the vehicle, lordship.
Vehicle.
1+1.
That,
Accordingly, on the basis of this registration.
no, but
certificate,
whether it implies that both are covered.
lordship,
This is the particulars of the, it speaks about seating capacity.
seating capacity.
The coverage is under liability, which is,
Accordingly, insurance company issued the policy. Considering the seating capacity of the vehicle, lordship.
no, this is not. What is covered is under the liability clause that is in the second page of the policy.
Leaving aside that, lordship. They have not raised their defense in the court below. That is my only submission.
That
Yes.
submission.
Yes, lord. Now, what is submitted before this court, that has not canvassed before the court below as their defense. So since other grounds are not raised, so I have no more submission in this case.
And in support of your submission in a MACT case, if they have not raised the question as to who is covered under
Yes,
insurance
also,
policy,
that has not been
before
done
the-
at all.
they cannot raise it now.
Now, lord. They cannot.
That is your submission. In support of your submission, do you have any authority?
I have not come with the authority.
If you can collect you.
But fact is that unless the said,
No, I have understood your
Yes,
submission. Your submission is clear. But if possible, you,
I can give it tomorrow, lordship.
yes,
Yes, lord.
tomorrow, day after tomorrow, even on Monday you can give. Tomorrow you can give wherever.
Yes, lordship. Yes, lordship.
Okay. Because only that would be countering the submission of
Lordship.
the appellant. Otherwise, Supreme Court has stated very clearly. Okay, heard Mr. V. Devnath, learned counsel for the appellant. Also heard Mr. B. N. Sharma, learned counsel for respondent number 1, 2, and 3. And Miss Moa Jungla, learned-
Respondent number 4.
who is respondent number 4? The
Owner, driver and owner of the.
or respondent number 4. Just I am asking out of query, what happened in the earlier case which you were defending? The earlier case was similar case.
No,
The-
issue
no.
was different.
There also pillion rider was covered.
There is a position.
The policy was covering. Okay. Moa Jungla, learned counsel for respondent number 4. Hearing concluded, judgment reserved.
With your lordship, if I may be bound to point out one thing. As my learned senior colleague said that we have not taken the ground, that the policy part. So it is well taken in my written statement, lordship. Written statement in the LCR, paragraph number 2.
Regarding coverage,
No, regarding the policy. If I may read that particular paragraph for your lordship.
okay, read it.
That the claim application is absolutely bogus, frivolous, and untenable under the law. That the motorbike bearing number AS07A8248, in which the deceased was pillion rider, was not insured to cover the pillion rider's liability on the policy. Therefore, insurer, that is OP number 2 and 3, are not liable to pay any compensation to the claimant. However, if liability arises, it may be fastened to rider come owner of the alleged bike. Lordship, when we have taken the defense, lordship, and the law is very clear, lordship. And even in the Supreme Court judgment, it is well established, it is clearly specified.
Who is who was driving the bike?
Owner.
Owner is the father.
No. Owner was the friend.
Owner, he's the owner term letter.
Owner come, no.
My son was the pillion rider.
Okay. No, his lordship is asking who was the owner. Owner was the friend of the deceased.
I don't know.
No, who is number 4? Number 4 is the owner.
Yes, number 4 is the owner come driver of the motorcycle.
There is no relationship between.
No relationship.
So assuming that court is convinced with the plea of appellant, then and he is exonerated, then liability would shift to
The
respondent.
owner. No, here in this case, pay and recover will not come. Lordship.
It may be pay and recover also there.
In this case, pay and recover will not come.
Otherwise, also 50% of the award is already allowed to go by that.
That may be returned back to the Supreme Court is clear, lordship. Yes. Supreme Court is clear. In the
Judgment,
I have
hearing
done.
concluded, judgment reserved. You submit your respective authorities tomorrow. Whatever.
I'm giving it now, that paragraph.
Okay.
Yeah, please, Your Honor, on item number 28, which we heard earlier, in that case, statutory deposit is there, so in the order to return it, it may be reflected to return the statutory deposit of 25,000. In case of, yes,
In case of appeal being allowed,
yes,
otherwise it will be adjusted.
adjusted, yes.
Okay.
Okay.
Finish.
Judgment, yeah.
Judgment reserved. CAV. Yes, condemnation.
Item number 28, yes, no.
Procedural.